Yes, Your Honor, but before we begin, may we make appearances before the court?
Certainly.
Good morning, Your Honor. My name is Nicholas Crossland, and along with my co-counsel, Josh Borsakowski.
Good morning, Your Honor.
And Brandon Duran.
Good morning, Your Honor.
We represent the plaintiff in today's case, Andy and Lee Park, on behalf of the deceased Sydney Park. Before we begin, Your Honor, the plaintiff has some housekeeping matters to address. First, we'd like to ask your permission to move about the well during statements and direct and cross-examination.
If you're actually going to.
Of course, Your Honor. And we would also like to ask if you would prefer us to ask permission when we intend to approach the bench, the witness, or opposing counsel, or if we just simply let the record reflect when we do so.
Permission to approach opposing counsel witnesses only, otherwise just let the record reflect.
Thank you. And we actually have some documents we'd like to tender to the bench at this time. These include a copy of the Midlands Rules of Evidence, relevant case law for today's proceedings, a copy of the statutes that are issued here today, the pretrial orders by Judge Jackson, a copy of the stipulations that will govern today's trial, a copy of the special instructions that will govern this activity, and the complaint filed by the plaintiff against the defendant. Permission to approach the bench.
Does opposing counsel see this right?
Yes, Your Honor.
And you don't have to ask permission.
If I could draw your attention to page 2 of these statutes I just handed you.
Which are where relative to the
They should be ahead of case law behind the complaint. Page 2, section 1038A, imputation for liability for certain willful misconduct. This states that any act of willful misconduct by a minor that is the direct and proximate cause of injury to another person shall be imputed to any parent or legal guardian who had custody over that minor for the purposes of civil damages. Now, we, the plaintiff, we're suing the defendant for intentional shooting. We intend to prove here today that the defendant's son, Jesse Duran, committed an act of willful misconduct by shooting and killing the daughter of the plaintiff. If the jury finds in favor of the plaintiff in this regard, then the defendant, Ms. Hayden Duran, must be held vicariously liable for the actions of her son.
Understood. Thank you, Counselor.
And we'd also like to draw your attention to section 1056, directly below it. And this states that any statements by the defendant's son, Jesse Duran, are imputed to the defendant in today's case. Any statements by Jesse Duran are considered an admission of party opponent for the plaintiff here today, and are therefore not hearsay. I'd like to draw your attention to the pretrial orders from Judge Jackson at this time. Specifically to order number 2, Jesse Duran's post-shooting statement. The court has already ruled that Exhibit 1, the statement written by Jesse Duran immediately after the shooting, is admissible into evidence at any time before resting our case in chief without any foundation necessary. In line with that motion, I'd like to offer Exhibit 1 into evidence at this time.
Is that also your understanding?
Yes, Your Honor.
All right, let the record reflect approaching the bench to tender this exhibit. Also, Your Honor, we would like to ask your permission to use a pre-incident photograph of the deceased during opening statements, which has been marked as Exhibit 17. Opposing counsel has already seen it, and we'll be introducing this exhibit into evidence with our very first witness called here today. Thank you. Your Honor, at this time, we'd like to designate Ms. Andy Park as our party representative in today's case, pursuant to Section 4 of the special instructions. And in line with that, we would also like to move for the constructive sequestration of all witnesses, save for Ms. Park as our party representative, pursuant to Midlands Rules of Evidence Rule 615.
Do you have any objection to that?
No, Your Honor.
And with that, the plaintiff, we have no further housekeeping matters to attend to.
Thank you.
Your Honor, may I proceed?
Certainly.
My name is Abigail Hope, along with my co-counsel, Zach Graham,
Good morning, Your Honor.
and Caitlin Coffey.
Good morning, Your Honor.
We represent the defendant in today's case, Ms. Hayden Duran. Now, I have one document that I would like to tender to the bench. Opposing counsel has already seen this document, and it is the answer Ms. Duran filed in response to the plaintiff's complaint. Let the record reflect when I report to the bench.
Does opposing counsel see this document?
Yes, Your Honor. your attention to page 2 of the relevant statutes, specifically section 2.13, plaintiff's conduct as defense to liability. So today we will be raising the affirmative defense of comparative fault in response to the plaintiff's allegations. Now, section 2.13 states that a plaintiff's own wrongful conduct is a defense if the plaintiff's level of culpability was as great or greater than the defense's level of culpability, and the plaintiff's culpable actions were at least as responsible for the harm suffered by the plaintiff as the defense's harmful actions. This means that if the parties' wrongful conduct reaches the same culpability as the defendant, then the defendant cannot be held liable. Now, I would also like to draw your attention to page 2 of the relevant case law, Ultra v. Nyper. This states to impose liability on a parent or legal guardian for count 2 intentional shooting, a plaintiff must prove the following elements. First, the defendant had custody and control over a minor child. The child committed an act of willful misconduct. The plaintiff suffered injury or death, and the willful misconduct by the child was the direct and proximate cause of the harm suffered. Next, I'd like to draw your attention to Bornstein v. Piercy on page 2 of the relevant case law. This states that any conduct imposing liability for intentional physical harm is necessarily willful misconduct for purposes of count 2 intentional shooting. In contrast, conduct that is simply reckless or negligent is not willful misconduct for this purpose. This means that Hayden Duran cannot be held liable for her son's actions if the jury finds that Jesse Duran acted either recklessly or negligent. To be able to find the defendant guilty, the plaintiff must prove that Jesse Duran committed an act of willful misconduct, that he knowingly intended to shoot Jesse Parks. Now, I'd also like to draw your attention to page 7 of the relevant case law, to case Davis v. Happy Land Toy Co. This states case that in a wrongful death suit, as this is, the deceased is considered a party for evidentiary purposes. So this means that any statement offered here from the deceased Sydney Park on behalf of the defense is not hearsay, as it falls under the party opponent rule. And now, at this time, Your Honor, we would like to designate Ms. Hayden Duran as our party representative in today's case, pursuant to Section 4 of the Special Instructions. And with that, we have no further housekeeping matters.
Your Honor, if I may interject for a moment, during their pretrial orders, opposing counsel said they'd be raising the affirmative defense of comparative fault. If I could just draw your attention to page 3 of the case law, at the very top of the case, Riley v. Jones. Now, because part of our charge here today is to show willful misconduct on the part of the minor child, this case law states that the defendant cannot escape liability by establishing comparative negligence, recklessness, or assumption of risk. Those affirmative defenses are simply unable to be used in an intentional shooting ground, as you cannot prove comparative intent, Your Honor.
Do you have a response?
No.
I would just like to make clear then, I would ask opposing counsel to refrain from making any mentions of the comparative fault defense during openings and closings as to potentially confuse the jury as to issues that have no relevance legally here today.
I don't know if you can ask that of opposing counsel, but certainly reflects that instruction here that the jury would argue whether or not.
Yes, Your Honor. Thank you. With that, we are ready to proceed.
Your Honor, may I proceed?
Just we need 1 second. Go ahead.
For proceeding, thank you. ready. May I proceed? Your Honor, opposing counsel, members of the jury, may it please the court. This is Sydney Park. Well, this was Sydney Park, because Sydney Park was tragically killed at the pull of a trigger by Jesse Duran. It all started on the morning of August 18th, when Jesse Duran and Sydney Park had a plan to stay at Sydney's house while her parents were away at work. See, Sydney and Jesse were neighbors, and they played all the time. This hangout, however, was different, because for the first time, they would be in the same house without any parental supervision. And Sydney's parents owned a gun for self-defense. Except Sydney secretly knew the password to the safe that it was kept in. And her mistake? Well, she told Jesse that she knew the password. On the day of August 18th, Jesse Duran convinced Sydney to break into her parents' safe and pull out the gun. See, the kids had their fun playing video games that involved guns, but they'd never held a real one before. So playing with a real gun was all fun and games for Sydney, but Jesse had much darker intentions. See, without Sydney knowing, Jesse loaded the gun. And when Jesse was able to then next get his hands on the gun, well, he pulled the gun up with his right hand, stretched it out, pointed at Sydney's face, and pulled the trigger. Unfortunately, Sydney Park did not survive. Jesse Duran sought the gun. He shot the gun. He got the gun, and he shot the gun. Sydney's mother, Andy Park, will be called to the stand today. Andy Park will tell you about how she lost her only daughter, how her life has been forever altered after this incredibly tragic incident. Today, we, the plaintiff, are suing the defendant with intentional shooting. We ask you, the jury, to find by preponderance the evidence, meaning simply that you are 51% confident that Jesse Duran committed this act willfully and intentionally. See, Jesse had actually been planning this. Earlier that day, Jesse texted Sydney, saying he couldn't wait to see the gun. He even conducted searches on the internet. How to load a revolver, how to shoot a revolver, even what happens after you shoot a revolver with the recoil. See, today, we are here to determine whether or not Jesse Duran intentionally pulled the trigger that day. However, the defense will claim that this horrible tragedy was the result of an unfortunate accident. Yet, we will be calling an expert to the stand, Jules Sebastian. Jules Sebastian is a lead forensic investigator who was there that day and investigated the bullet that was fired from that gun, the very gun. And he found that the only fingerprints found on the casing of the bullet that was fired were none other than Jesse Duran. Only Jesse Duran could have loaded that gun. Now, I said it all started on August 18th. Well, that's really not true. See, it all really started long before that. See, throughout his childhood, Jesse Duran, that is, he constantly displayed incredibly concerning behavior. At school, he would threaten his fellow classmates, telling them that they should lie down and die. One time, he went to his neighbor's house and drowned their cat. Not only did Jesse have a fascination with violence, he also had a fascination with guns. In fact, Jesse's behavior is so concerning that we will be calling Dr. Couples to the stand, an expert in childhood psychology. He will tell us that Jesse's behavior is concerning not only as a disturbed child, but it is in line with that of a clinical psychopath. Now, members of the jury, I want you to remember to recognize this fact. Those who display psychopathic tendencies are much more likely to commit an act of harm against another human. And not only this, but those who display these tendencies are significantly less likely to display any pity for this action. And Jesse Duran simply didn't feel pity for his actions. Members of the jury, I want you to see this note that Jesse Duran wrote to the police department as a confession. I shot Sydney Park in the head. His apology? One word. Sorry. Now, it's also important to note his psychopathy because a common trait of those who display these tendencies is the ability to lie and to win, to be incredibly manipulative. And for the jury, I want you to remember this during the testimony here today, because I want you to piece together what you truly think happened. at the end of today's trial, my co-counsel Duran, will come before you and ask you to make the only ruling consistent with the facts and consistent with the evidence, and find the defendant liable for intentional shooting. Thank you.
Yes, Your Honor, may I proceed? Your Honor, opposing counsel, ladies and gentlemen of the jury, there are some fundamental differences with how the plaintiff and the defense sees the case. However, one thing that we can all agree on today is that the death of Sydney Park was a tragic accident. This was an event that was tragic, and something that we all agree that should not have occurred. But what opposing counsel is going to try to convince you of is that Jesse Duran intentionally shot Sydney Park on August 18th, 2010, when Jesse Duran decided to go over and visit Sydney Park. Ladies and gentlemen, this could not be further from the truth. This is where the plaintiff and ourselves see things a little bit differently. Jesse was a kid. He wasn't a killer. On August 18th, 2010, Jesse Duran went over to the home of Sydney Park to visit their daughter, Sydney. Sydney and Jesse had been friends for many years. In fact, a large reason as to why the Parks moved to their Maple Street address was because of the close proximity to the Durans. The Parks often watched Jesse. They would watch him after school, and they invited him into his home with open arms. Now, even though the Parks had a daughter who was 11 years old, and that daughter had a friend who was also 11 years old that constantly came over to the house and made visits, the Parks decided to own a gun. They decided to purchase a revolver in which they stored in their bedroom, a bedroom in which Sydney had access to at all points. But the gun was in a safe. That shouldn't have been a problem. Except the Parks made the egregious error of putting the combination to the safe in a drawer that was easily accessible by Sydney Park and her friends at any time, and this drawer was labeled important documents. Now, it doesn't take a brain surgeon to find a 3-digit combination and figure that that could be the combination to the safe. The plaintiff wants to believe that Jesse intentionally shot Sydney Park, and what this means is that Jesse had in fact knowingly, with intent to kill Sydney by shooting her. And further, that this means if there was intent to shoot, that this must have been the direct cause of Sydney's death. But again, Jesse wasn't a kid. He was a killer. Wasn't a killer, he was a kid. Sydney and Jesse decided to play a game that they had seen in video games on August 18, 2010, after they had gained access to this. They decided to play a game which resembled Russian roulette a little bit. Now, unbeknownst to Jesse, the gun wasn't loaded, or the gun was loaded. He didn't know that the gun was loaded. So this game that they decided to play, Sydney reached out, she pointed the gun at Hayden, and she pulled the trigger. But nothing happened. So Jesse, following suit, decided to play the game, decided to take the handgun from Sydney, he would point the revolver at her, and he would pull the trigger. Now in that moment, Jesse Duran looked down, and he saw 11-year-old Sydney Park, his best friend, die. Dead. Now in that moment, Jesse Duran was overcome with grief, with remorse. Jesse Duran didn't know what just happened. As far as Jesse Duran was concerned, this gun wasn't loaded. This was a gun that Sydney insisted wasn't loaded. She pulled it out of the safe. The ammo was supposed to be kept in a different area. Ladies and gentlemen, today we're going to call 3 witnesses. We're going to call Hayden Duran, the mother of Jesse Duran, the defendant. Now, Ms. Duran is the party opponent today, and she will be testifying as to Jesse's behavior leading up to this event, as to Jesse and his character. Second, we're going to call Ash DeRosa, who's going to talk about gun safety, gun storage, and that type of thing. Next, we're going to call Jesse Duran. Jesse Duran is going to tell you all about his side of the story and what occurred on August 10th, 2018. Ladies and gentlemen, we have to remember that this is a civil case, not a criminal case. That means two things. First, the police and the district attorneys reviewed all the evidence and the facts in this case, and they found that at no point was Jesse Duran or Aiden Duran supposed to be charged with anything. Second, this means that you must find by preponderance of the evidence, meaning more likely than not, that Jesse Duran intentionally shot Sydney. And we, the defense, are confident that today, after you see the facts and hear the testimony, that you will find Jesse Duran not liable of intentional shooting. Thank you.
Your Honor, at this time, the plaintiff would like to call its first witness. The plaintiff would like to call Mrs. Andy Park to the stand. Your Honor, permission to proceed. Could you please state your name?
I'm Andy.
And where did you live between 2004 and 2000?
We lived on 23. We moved after Jesse's name.
Your Honor, permission to approach opposing counsel with proposed exhibit 17. May the record reflect I'm approaching the witness with proposed exhibit 17. Could you please identify what I just handed you?
This is Sydney. I taken it to the section sheet. 11. I did. So what was it?
I'm sorry for your loss. May the record reflect that I am approaching the witness to retrieve proposed exhibit 17. And the plaintiff at this time would like to enter proposed exhibit 17 into evidence.
No objection, Your Honor.
Permission to come to the bench. Had Jesse Duran been in your home before the incident?
Yes. And Sydney were friends. They would come over and play video games. They hung out locker in the summer.
And what would usually happen when Jesse came over to the place?
Jackson would usually bring awful violent video games. He didn't want Sydney around that type of stuff. So I would always tell him that he had to put it away. That he would get upset sometimes, but would ultimately follow my rules.
And besides August of 2010, were there any other visits from Jesse Duran that you found notable?
Yes, there was one time in May that he brought over a particularly violent video game, and I told him that I had to take it away.
Objection, Your Honor. Hearsay as to Ms. Park's statements.
Your Honor, may I hear? The witness isn't specifically stating, the witness isn't saying something that's a particular statement. She's simply describing an instruction that she gave to Jesse.
The testimony I heard was I told him that I had to take it away. Sounds like a specific statement to me. That was no response.
Your Honor, that statement goes to the state of mind of the witness, not to, we're not offering the statement for the truth of the matter asserted. We're simply offering it to Mrs. Park's state of mind at the time, that she felt she needed to take it away. Whether or not that was necessarily true is not something we're saying.
Your Honor, if I may be heard, specifically under Rule 803, exceptions to hearsay, then existing mental, emotional, or physical condition, or also Ms. Park's state of mind, is an exception to hearsay. So opposing counsel offering this statement as not hearsay and saying it is not hearsay because it shows your state of mind is offering that statement as hearsay, and I do not believe the foundation has been laid for the statement to fit under that exact, exception, Your Honor.
Understood. I don't think I have a copy of the rules of evidence, by the way. So I don't know why you lied to me across it, but do you have an extra copy? Does anyone have an extra copy?
I can give you my phone.
Well, I would want to my phone. Yeah, give me a second to do that, actually. Some people also have one copy every 3 days. Love printing those.
I also have my laptop, if you want a bigger version to keep in front of you.
During recess, we can grab a copy.
Oh, yeah.
Let me just, sorry,
Specifically page 10 of the Midland Rules of Evidence, Your Honor.
appreciate it. You're a sucker, but I appreciate it. Zach, you caused the. Forgot to give you Wi-Fi was so fucking annoying to log on.
Yeah, that Wi-Fi really sucks.
I mean, your opening's over, I'm gonna give you extra points now. Said page 10.
Yes, Your Honor.
Alright, Brennan?
Your Honor, you're asking me to respond to it.
Yeah,
Uh,
if you have a response.
Your Honor, we can just retract that one particular statement and ask the question again.
So you don't have a response?
Your Honor, my response would be that, because it's not being asserted because it's not being offered for the truth of the matter asserted, it's not hearsay, and I will retract the one exception that I argued for, which was the state of mind.
Your Honor, if I may be heard, if opposing counsel is not offering this statement for the truth of the matter asserted, I would like to ask opposing counsel what he is offering it for, because if it is not going for the truth of the matter, it has to be going towards something else.
Your Honor, it's not evidentiary, it's just establishing the interactions that Mrs. Park had towards Jesse Duran. It doesn't have to go to the truth of the matter that Mrs. Park needed to take away the video game from Jesse Duran. It's simply explaining further actions.
I'll take that. Don't tell me it's not evidentiary if you're trying to introduce it to evidence as part of your testimony. But I'll say that it's going towards subsequent action.
Yes, Your Honor.
Thank you. Would you like me to ask the question? Would you like me to ask the question again? Besides August of 2010, were there any other visits from Jesse Duran that you found notable?
Yes, there was one time in May when Jesse had brought over a particularly violent video game. I told him I had to take it away, and he threw a screaming, crying fit. He eventually calmed down, but it was unusual. Never seen him cry before.
Thank you, Mrs. Park. I'm sorry to do this, but I'd like you to take us through the tape, please. What happened first that day?
My babysitter had canceled on me that day. I had talked to one of my neighbors and asked if he would he said he would, and that he would check on the kids every couple of hours. He had left Sydney home before about a week.
That day, did you inform Mina Duran of this?
Yes.
So what happened after you explained that to him?
She seemed a little apprehensive as were I and me, but we all had to go to work. There wasn't much we could do.
And what happened once you got to him?
I was about 30 minutes into my workday when I got a call from the police.
And what did the police tell you?
They told me that there had been an accident.
Objection, Your Honor. Hearsay as to the statements from the police. This is an out-of-court statement being offered in court for the truth of the matter asserted.
Response.
Your Honor, the statement's being used to explain the subsequent actions. The truth of the matter of what the police told. The truth of the statements the police told to Mrs. Park is irrelevant. We're only offering it to explain Mrs. Park's subsequent actions after hearing the statements by the police.
Did the witness finish the statement?
No, she finished half the statement.
What was the full statement the witness said? The police told me that there had been an accident.
That's what she did.
witness's subsequent action.
Your Honor, if I may properly, the witness's subsequent action would be driving home to her home to see what happened at the house.
I don't think the statement is particularly important for either side, so I'll accept it for subsequent action.
Thank you, Your Honor.
We all know an accident happened, so.
And what did you do after the police told us?
My heart dropped. I was imagining all the scenarios that could have happened. Nothing could prepare me for what actually happened. My 20-minute drive home turned into an 11-minute drive. When I got to my block, I saw emergency vehicles everywhere.
What did you do after driving to the block?
I got out of my car. I wanted to see Sydney. I wanted to know that she was okay. I got into my house. I saw her pink sparkly flip-flops that she had just begged me a week before to buy. They were on the ground, and she was covered by a sheet. I was confused. I couldn't figure out what happened. I realized that she was gone.
What did you do?
It was hysterical. You're not supposed to die before your kids. You're not supposed to bury your kid.
Mrs. Park, can you please explain to the court why you're bringing this lawsuit here today?
Jesse Duran is the reason that my Sydney didn't get to have the 12th birthday party. Jesse Duran shot and killed my daughter.
Thank you, Mrs. Park. No further questions.
Commission to proceed, Your Honor.
Yes.
My name is Dr. Hill, and I'm just going to ask you a few questions to clarify your testimony. And if at any point you need a moment, please just let me know. Now, you moved to Fairview in May of 2004, and you moved there with me and Sydney because of Katie Duran.
We knew that Jesse and Sydney were friends, and she'd been a little antisocial in school. Couldn't really make that many friends. We thought it would be good for her.
Now, when Sydney was 5, you moved into the house right next to Duran.
We did.
Because you wanted Jesse and Sydney to be able to hang out together.
Yeah, we thought it would be good for Sydney. Clearly, it wasn't.
Now, Ms. Park, you stated that the best part of living in Fairview was living next to you and Jesse. Is that correct?
It was the best part, and then it became the worst part.
Now, Jesse would also spend a lot of time in your house.
He did. He had to work a lot. And I understand. We would often watch it.
So you specifically would sometimes watch Jesse.
Either me, my husband, me, sometimes a babysitter, depending.
And Jesse would sometimes want to play his video games at your house.
He did. We didn't really allow that. We only wanted to be playing either games.
So you would tell Jesse no. Is that correct?
Yes.
And Jesse would always comply with you. Is that correct?
Sometimes he would be a little upset, but he usually followed our rules.
He always followed your rules. Is that correct?
Yes.
Now, you bought a gun in January of 2010.
Yeah, we had a break-in for it. We just wanted the gun to feel safe in our home.
And you're very experienced with guns.
Yes. We and we both know how to use the gun. We wanted to make sure that if we were going to have it, we were able to use it safely.
You kept the gun in a safe.
Yes.
And the safe was in your bedroom.
It was.
And Sydney had access to your bedroom.
Objection, Your Honor, relevancy.
Your Honor, if I may be heard, a fact is relevant if it makes any other fact in this case more or less likely. Now we're here to talk about the intentional shooting of Sydney Park and how these children got their hands on the gun specifically, especially when it was kept in a safe. It's very relevant to today. So whether or not Sydney had access to Auntie Lee's bedroom is very relevant.
Your Honor, if I may be heard, according to case law by Larissa Jones in the intentional shooting case, a comparative flaw in establishing the assumption of risk is irrelevant to today's case, and the security of the gun and how the park secured the gun, where the gun was located in the house, would only be relevant, would only make a fact more or less likely if the argument of comparative flaw was being used.
Your Honor, if I may be heard, regardless of if I'm using this to go towards concurring fault, it is still relevant as to how two 11-year-old children were able to get their hands on the gun. That is why I'm bringing up this line of questioning, is because it's important for the jury to understand how the events unfolded.
Yeah, I understand what you're saying. I don't think it's potential an issue with the sort of round, but the chain of events that led to the shooting is still relevant. So I'm going to overrule the objection.
Yes, sir.
Thank you, Your Honor. So Sydney had access to your bedroom.
She was also there for
Now, the combination to the safe was 37, 14, 41. And these numbers represented yours, Lee's, and Sydney's birthdays. And Sydney was aware of these dates.
She knew our birthdays. She would always make us a card all the time, so she was aware of the dates, but we didn't tell her the order. We didn't tell her anything about. We didn't tell her what the combination was. She could have thought it was the years of our birthday. She could have thought we did the day first or the month first, but she knew our birthdays.
So that's a yes to my question.
And it was,
Now, you kept the combination to the safe in your drawer in your desk.
yeah.
You didn't lock this drawer.
No, it had a bunch of other files in it.
You caught Sydney going through this file drawer.
That was after I had taken over Jesse's video game appointment, and she was trying to find it for him. Considering our combinations and for emergencies only section of that drawer, I had no reason to believe that she would be looking in the emergency file for a video game.
But yes, you did catch Sydney going through the file drawer where the combination was kept.
Yes.
And despite this, you did not relocate the combination to the safe. That's correct.
No, I did not. Again, I had no reason to believe she didn't open the file.
However, you didn't relocate it even though you now knew that Sydney had access to the combination.
Objection, Your Honor, to review my objection to relevancy. While we've established that the opposing counsel can create a line of questioning as to explain the events leading up to the shooting, specifically asking Mrs. Park what she did or did not do or what she failed to do about securing the gun would still fall under the argument of comparative fault, which would still be disallowed according to our decisions.
Your Honor, if I may be heard, as you'll hear through later testimony, you'll hear how specifically, if I may proffer, from Jesse Duran, how the children were able to obtain the gun. So to be able to fully understand that, I think it's important for the jury to know specifically how, what kind of actions were taken by the Parks for either securing the gun just because the children were able to get their hands on it. So it's relevant as to why they were able to.
Your Honor, may I be heard? While the opposing counsel has already established how Sydney Park and Jesse Duran may have found the information for the safe, that could be considered relevant, but whether or not Andy Park or Mrs. Park or the Parks in general took subsequent actions after that to further secure the safe would be irrelevant, considering that opposing counsel has already established that Sydney Park had been in the general vicinity of the combination.
I agree with that. I think, as a general rule, Sydney and Jesse's knowledge and actions pertaining to the gun ahead of time are relevant. General information about how the gun was found and the conditions sound relevant, but what this Park did or did not do to secure the gun, I believe is verging too close to comparative negligence. So I'm going to sustain your objection.
Thank you, Your Honor.
Yes, Your Honor. You later learned that Sydney was aware that there was a gun in the house.
Yes, I was shocked to even know how she knew that. We never told her.
In fact, you heard her say, "I'm sure it's in your bedroom."
I did hear her say that, but the gun was in a safe, so I had no reason to do it. It's in a safe. She had no access to the safe itself.
Or she did have access to the safe.
Yeah, she didn't have the ability to open the safe.
Now, you kept the bullets to the gun in the garage.
Of course, we don't keep the bullets in the safe because it's a gun.
However, Sydney had access to the garage.
Of course.
Now, I know this might be difficult, but Ms. Parks, you blame everything that happened on August 18, 2010 on Jesse Duran.
I do because he is the reason my daughter is in here.
You want Jesse to go to jail.
I want.
Objection on irrelevancy.
Your Honor, this goes towards potential bias. It's very relevant as to Ms. Park's personal feelings towards Jesse Duran.
I mean, the bias has already been established given the fact that Jesse Duran shot Mrs. Park's child. I don't think whether or not Mrs. Park wants any criminal action against Jesse Duran is relevant, considering that this is not a criminal trial to begin with.
I believe that, the witness wanting a, I believe, 15-year-old today to be sent to jail because of what happened is further evidence of bias. Whether or not it is already been established by the defendant, doesn't necessarily mean that opposing counsel can try to pursue that further. So I'm not going to do that.
Thank you, Your Honor. So, Ms. Park, do you want Jesse Duran to go to jail?
I want Sydney's life to be beautiful. It's not fair that Hayden gets to have the 12th birthday and the 13th birthday with their child. And I don't even get one more birthday with her. I don't get one more Christmas. I don't get one more holiday with her.
Now, you believe that Jesse intentionally shot Sydney?
I do.
Now, you believe that Jesse was influenced by video games?
That's just considering the types of video games he would bring over to my house, yes.
Ms. Parks, I want to make this very clear. You didn't actually think any of this before August 18, 2010, is that correct?
I thought video games were violent and I didn't want those video games exposed to my daughter, but I didn't think that something like this could happen.
In fact, you didn't think that any of Jesse's actions before August 18, 2010 indicated that an accident of this type could ever take place, is that correct?
I didn't think he was a murderer. That's wrong.
But you never thought that any of Jesse's behavior would make an accident like this likely, is that correct?
That's a mistake.
Thank you. No further questions, Your Honor.
Right.
No redirect, Your Honor, I just asked that my witness have permission to set that information.
Does plaintiff have another witness to call?
Yes, Your Honor. At this time, the plaintiff calls Jules Sebastian. Ms. Bennett. Permission to proceed? Could you please introduce yourself to the court?
My name is Jules Sebastian.
And what is your profession, Mr. Sebastian?
I've been the lead forensic investigator for Breckenridge County for 5 years, and before that I was an assistant forensic investigator for 12.
What is your educational background?
I received a bachelor's in criminology from UNC Charlotte, and after that I went to the John Jay College of Criminal Justice to receive a master's in forensic science. And then I decided to be a police officer, and I graduated second in my class, over 300 at the State Police Academy.
And what type of training do you have in regards to crime scene analysis?
I have extensive training in all facets of forensic investigation, which includes things like ballistics, gunshot residue analysis, blood splatter analysis, hazard evidence collection and preservation, which is a much more comprehensive subject than you would guess, fingerprint analysis, all of those things.
And what methods did you employ when you commit crime scene analysis?
I use the gold standard of forensic methodology investigation that they teach in the Newlands Police Academy. It's standard in the state, as it's what they teach in the academy, and it's very effective, as a known error rate of 0.069%. and I reliably applied this method when investigating this particular incident.
How did you become involved in today's case?
Well, at 10:06 a.m. on August 18th, 2010, I received a call from Officer Dale Williams that there was an incident at 23 Maple Street in Newlands. So I head over there immediately, and I arrived on scene at about 10:23 a.m.
And what happened after you arrived at the scene?
I entered the premises and I saw Officer Dale Williams with another individual, a young boy, who their name was Jesse Duran. And as I entered the living room, I saw the body of the victim. It was a young girl who I later learned was Sydney Park, who resided at that residence.
And what evidence did you collect from the scene?
After seeing the body of the victim, I found a 6-shot 9mm revolver on the ground in the living room, close to the coffee table.
And would you recognize a picture of this revolver I showed to you today?
I would.
Your Honor, permission to approach opposing counsel with what has been marked as proposed exhibit 18. And let the record reflect the approaching witness and exhibit 18. Would you like me to approach the copy?
Yes.
Could you please identify by his name?
This is the 6-shot 9mm revolver manufactured by A.D. Baker & Co. I recovered on scene at 23 Maple Street.
And is this a fair and accurate depiction of that revolver?
Yes, it is.
Thank you. Your Honor, at this time I'd like to submit exhibit 18 as evidence.
There are no numbers on these exhibits. Is that an issue with printing, or is that?
AMTA didn't label him as
Got it. Right. In that case, can everyone please make sure when you're referring to the exhibit to clarify what it is, as well as the number, because I have a couple of stickers.
How did you analyze this revolver?
Well, I picked it up and I found there was one spent shell, and to test whether or not the bullet that killed City Park was fired from this revolver, I fired a test bullet and I compared the striation marks on both bullets, and they were comparable, which means that it's very, very likely that the bullet that killed City Park was fired by this specific revolver.
Did you analyze the trigger of the revolver?
I did analyze the trigger. It requires about 4 pounds of pressure. 4 pounds of pressure to trigger it, which then would fire the firearm. And from my experience, any somewhat developed person, probably at the age of 5, can exert that amount of pressure on a trigger.
And did you dust this gun for fingerprints at all?
I did. I found 4 full fingerprints, 1 belonging to Andy Park, 1 belonging to Sydney Park, and then 2 belonging to Jesse Duran.
Thank you. Well, let's reflect an approaching witness to retrieve the exhibit. Did you dust anything else for fingerprints that day?
I dusted the shell, and I found 2 partial fingerprints of Jesse Duran. Well, these, since they're partial, they were not conclusive enough to determine for a fact that they were Jesse Duran's fingerprints. But since the only 4 fingerprints on the gun were Andy and Sydney, as well as Jesse, and those fingerprints, the partial prints did not match up, and there was no consistency with Andy or Sydney Park. That means those partial fingerprints were very likely Jesse Duran, meaning he was the one that loaded the revolver.
Thank you. And did you perform any other crime scene analysis?
I performed a gunshot residue analysis.
Could you explain to the jury what gunshot residue is?
Gunshot residue are tiny particles that are expelled from a firearm once it's fired. They're very useful in forensic investigation because you can use, by examining these particles, you can determine location and proximity from a firearm. So, for example, if I were to shoot a gun from my left hip, there would be much gunshot residue around my left hip. There would be a moderate amount on my chest, on my right shoulder, and there would be very few, let's say, living.
And where did you find gunshot residue that day?
I found 200 gunshot residue particles on Jesse Duran's right hand, 75 gunshot residue particles on Jesse's shirt, and only 25 on his left hand.
And what can you conclude from finding gunshot residue on Jesse Duran?
The disparity in the amount of numbers between his right and left hand tells me that he shot the gun with his right hand, most likely outstretched from his body, since there was much more gunshot residue on his right hand than his chest, and even less on his left hand, which means he did not shoot with both hands, he did not shoot anywhere else, he shot with the right hand.
Mr. Sebastian, are you aware that Jesse Duran claims he fired the gun holding it with both hands?
No, this is the first I'm hearing about this.
And does any of the evidence you found at the scene match up with that explanation?
No, if anything, the evidence points to the contrary, since there was 200 particles of gunshot residue on his right hand and only 25 on his left. That's 8 times more on the right than the left. That means that there's no way that he could have shot with both hands.
Thank you. I have no further questions, Your Honor.
Your Honor, may I proceed? Yes.
Just to clarify, was the picture of the gun ever formally put in evidence?
I believe it was that evidence.
I remember getting a courtesy copy, I don't remember officially.
I submitted it to evidence officially after he identified it was fair and accurate.
She didn't say sure.
She didn't say sure.
If opposing counsel has an objection to it,
I do not at this time.
but then we'll assume it's submitted in evidence.
Oh, we will?
Yes.
Hello, Mr. Sebastian. My name is Caitlin Coffey, and I just have a few questions to clarify your testimony today. So I would first like to discuss your expertise. So you have been an assistant forensic investigator for 12 years, correct?
Yeah, I was an assistant
And
forensic investigator as well.
And you became a lead forensic investigator in 2010.
Yes.
Because investigating Cindy Park's case was the first case you were ever the lead investigator for.
It was the first case I was the lead investigator for, but I conducted hundreds of cases doing similar things as an assistant.
But this was the first time you were the lead investigator, correct?
Yes.
Thank you. And you have conducted numerous previous crimes and investigations before.
Hundreds.
And you have investigated many cases that have to do with gun violence, isn't that right?
Yes, unfortunately, it's a major issue.
So, Mr. Sebastian, how many times have you responded to a shooting case where there wasn't a gun involved?
Wait, are you saying, can you say that again?
Yes, how many times have you responded to a shooting case when there was no gun involved?
Well, by the nature of it being a shooting, there is a gun involved. She means that if there's no gun recovered, I don't have that number off the top of my head, that happens, but if there's a shooting, logic follows, there must be a gun.
So, you would say that if there is a shooting case, there is always a gun attached, isn't that right?
Yes.
So you would say, with your expert knowledge, that if there wasn't a gun involved, there would be a significantly less chance of a shooting occurring.
Objection, Your Honor, to the relevance of this line of questioning.
Your Honor, if I may be heard, this relevancy shows if a fact is more or less likely. I am simply asking this expert if having a gun there present would cause a shooting more likely to occur. To understand the full facts of today's case, understanding Jesse Duran's ability to retrieve a gun would go as to the proximate cause, which is something the plaintiff has to prove today.
Your Honor, if I may be heard, if the purpose of this line of questioning is to further establish a comparative fault defense, and I would re-raise the objection my co-counsel made earlier as to Riley B. Jones, that defense
I
has
did,
to
do
be
you want to
raised.
hammer on that? But she just said it was going to prove proximate cause.
Well, Your Honor, if I may be heard, part of comparative negligence or comparative recklessness is proving proximate causation on the part of the plaintiff. So that still goes to that very same defense, just a different subsection of it. Also, the witness has already stated that he is not aware of any shooting cases that don't involve a gun. That's on the record, and yet she's continuing to hammer this question. It's been asked and answered several times at this point.
Can I say something? My understanding is that proximate cause is also shooting, but the shooting was the direct approximate cause of death. I may be wrong, or harm to the victim.
I believe you are correct.
Sorry, I'm having trouble finding the
Wait, which statute are you looking for?
intentional shooting.
It's,
Yep, no, I found it. So the willful misconduct by the child was the direct approximate cause of the harm suffering.
Your Honor, I would just argue that this isn't going to diffusing our burden of proving proximate cause, but it's going towards proving proximate cause on behalf of plaintiff, which would be a comparative fault defense.
Your Honor, if I may be heard, we are not saying or questioning whether the parks owned a gun or if owning a gun would further the fact that a shooting occurred. We are purely looking at the fact if our client were to have the ability to get a gun, would that further prove or would that further show that a shooting may occur?
Your Honor, if I may be heard, I'm not sure I fully understand opposing counsel's explanation as to why this is relevant. She just said she's not offering this to show that the parks owning a gun made it more likely for a shooting to occur. And I don't see how even not owning a gun is at all probative in today's case. The shooting happened at the park's residence. The park's gun is at question. Whether or not Hayden owned a gun doesn't make any fact more or less likely.
Your Honor, if I may be heard, we are looking at if Jesse had the ability to get a gun, if it's more likely that a shooting would occur. We are not saying that the park's owning the gun is the reason why he was able to get the gun, but we are showing that Jesse was in fact able to get a gun, which would lighten the chances of a shooting to occur.
Okay, we are extremely deep in the case. I don't love the responses that you're doing. Yes, I don't think you're explaining well why the approximate cause. So I'm going to say what I said earlier, which is it's relevant to show the chain of events that led up to the shooting. But anything that gets further into the likelihood or the fault of both parties, I'm not going to accept the evidence. So we get one response on this line of questioning and then move on. But for now, we'll
Yes, sir.
So, Mr. Sebastian, just to re-ask my question, the fact that a gun was present in the crime scene would lighten the chances of a shooting to occur, correct?
Are you saying that if the gun was there before the crime scene?
Yes.
Yes, I mean, you can't have a shooting without a gun.
Thank you. I would now like to discuss what other things you recovered that day in question. So when you arrived at the scene, you noticed a hand revolver on the floor, correct?
Yes.
And you immediately put it into a secure bag.
Mm-hmm.
But you put it into a bag before you put on gloves, isn't that right?
Yeah.
Which typically goes against protocol, correct?
Not necessarily.
You mean to say, Mr. Sebastian, having been a criminal investigator for over 12 years, that it is typical with protocol to not wear gloves when picking up evidence?
In the vast majority of cases, you're supposed to wear gloves, but some evidence, if you need to collect immediately, you don't have time to. So there are exceptions in the police protocol.
And Mr. Sebastian, you have studied fingerprint analysis, correct?
Yes, I've even taught this over at the academy.
Yes, you are so well learned. You know how the oils transfer on to different pieces of evidence, correct?
I am.
So your own fingerprint oils could have been found on different pieces of evidence, correct?
They could have, not on the revolver, because I dusted for fingerprints, and mine were not on there. Only those of Andy Park, City Park, and Jesse Duran.
But Mr. Sebastian, you were the only one who dusted for fingerprints, correct?
On the revolver, yes.
So no one else checked for fingerprints, just you.
That's the job of a forensic investigator.
A forensic investigator who wasn't wearing gloves, correct?
Wasn't wearing gloves at that time.
Thank you. And so you would say you picked up the bullet without gloves on, isn't that right?
Which bullet?
The bullet casing on the ground?
Oh, the casing. Yes, that's not the bullet.
And you were, thank you, and you were You only found partial fingerprints on the bullet, yes or no?
I found 2 partial fingerprints that had some similarities to Jesse Duran's full fingerprints that were on the revolver.
But they were only partial fingerprints.
Yes, they didn't. They weren't complete enough to definitively conclude one way or another if it was Jesse Duran.
A bullet casing that you picked out the golf clubs on, correct?
Yes.
And you also dusted for fingerprints on the revolver, correct?
I did.
And you found fingerprints belonging to both Jesse Duran and Sidney Park, isn't that right?
I did. There was two full fingerprints of Jesse Duran and 1 of Sidney.
But there was a fingerprint of Sidney Park.
There was.
And you also recovered fingerprints on the safe, isn't that right?
I did. Most of which were from Andy Park.
But there were also fingerprints that belonged to Sidney Park.
Yes, Sidney Park and Jesse Duran's fingerprints were on the safe.
And lastly, Mr. Sebastian, you recovered a set of fingerprints on the box of bullets, isn't that right?
I did.
And those fingerprints belonged to Sidney Park.
Yes, they did.
Thank you. And I have one last question, Mr. Sebastian, to ask you. Yes or no, as a criminal investigator for over 12 years, has fingerprint analysis ever showed the mental state of a person?
I mean, they're 2 completely different things. Forensic science doesn't deal with any motive or anything else. That's left for more detectives and investigators. Forensic science is dealing with the actual science of how crime scenes work. So you can't denote motive or intent or anything like that from forensic science.
So you would say with forensic science that you were unable to determine intent, yes or no?
It's not my job to determine intent, so no, I'm there to determine scientifically what happened.
Okay, thank you. No further questions.
Redirect your Did you find your fingerprints at all anywhere at the scene?
Nothing I dusted for fingerprints included my own.
So, despite the fact you weren't wearing gloves, was there any sign you contaminated the scene at all?
Absolutely none. And when I arrived there, the body of Sidney Park was already placed in a way where there would be no contamination, as it was a sheet over a mattress placed on all of their extremities.
Was there any sign anyone else had contaminated the scene?
I had no sign of contamination. When I only dusted a few things for fingerprints, mainly the revolver and the safe, and the only individuals that I had conclusive match fingerprints were members of the Park family and the Duran family.
And how can you conclude that Jesse Duran touched the bullet when you only have a partial print?
Because there's only 4 fingerprints on the gun. Andy, Sidney, and Jesse. Now the partial prints on the casing were most definitely not. There's no match to Andy and Sidney. So that means since only 4 people touched the gun and you need to touch the gun to load the gun, since you can rule out Andy and Sidney, that only leaves Jesse.
Thank you. No further questions, John.
Your Honor, brief cross.
Mr. Sebastian, when you arrived at the scene, you only swapped fingerprints for Terry Chapman, Jesse Duran, Andy Park, and Sidney Park, correct?
Yes.
So you did not have your own swapped fingerprint, isn't that right?
Well, the police station does. I didn't have to swab it there because when you get hired, you do. And when I did the fingerprint analysis, I went back to the lab, which has fingerprints of every single officer in the force.
And you never compared the partial fingerprints to what you found of your own?
No.
You only compared the fingerprints that you found on the revolver, on the box of bullets, on the safe, and on the bullet casing to Terry Chapman, Jesse Duran, Andy Park, and Sidney Park. Isn't that right?
Yes.
Thank you. No further questions.
Redirect your
Sure, I can't stop you.
Are there any similarities at all between your fingerprints and that of Jesse Duran?
Every fingerprint is different. That's why it's a forensic science. If there was cases where people's fingerprints were very similar, it wouldn't be used as a method of investigation.
So, you know that the fingerprint on that bullet most likely is not yours, right?
Yes.
Thank you, no further questions.
Your Honor, brief recross.
I'm gonna kill both.
Oh, no, just wait.
Mr. Sebastian, if you didn't have anything to compare to, how did you know you were looking at your fingerprints?
Say that again?
If you only had Terry Chapman's, Jesse Duran's, Andy Park and Sidney Park's fingerprints, how were you able to determine a partial fingerprint was in fact your fingerprint?
I never determined our being mine.
But how did you know that the prints existing on different pieces of evidence weren't yours?
Because I found two partial fingerprints. The entire case, two on the case. Since the gun only had 4 fingerprints on it, that means one of the people who touched that gun loaded the bullet. You can rule out 2 of them, which leaves the 3rd.
But Mr. Sebastian, if you looked at a fingerprint, would you know if it was yours?
Like, just like if I put it in like the ash.
Yes.
If it was in the lab, if it was on the computer screen, or
If you dusted it with the ash, would you know it's yours?
yes.
You would?
Yeah.
So would you be able to draw out your fingerprint right now?
Yeah. Do you have a marker?
Your Honor, due to budget cuts, the Midland City Courthouse does not have any markers.
Here. So I mean, I'm not a good artist. This is why we use computers, but my fingerprint, you can tell because there is a curve upward, and then I have a triangle underneath. You can see it if you like.
And because that is not a very accurate depiction, how would you know a fingerprint belonged to?
Because the fingerprint I dusted wasn't a drawing by me, it was an analysis by a very sophisticated computer system, which you can determine exact matches. This is a science used in every police department in the United States, and it's there for a reason.
But Mr. Sebastian, if you can't even draw it to memory, how would you look at it and know it was yours?
Well, I did draw it to memory.
But if you could not draw it accurately to memory,
Because I can't draw as anyone's fingerprint to memory because they're so small and there's so many little details that an artist can't do just on a dry erase marker. I'm sorry, I'm not Van Gogh. I'm Picasso. I am a cop. As cops, we use technology.
well, with the technology, you did not compare it to your own fingerprint, yes or no?
No.
Thank you, no further questions.
Read it down. Commissioner, witness to step down this time.
Yeah, good job.
Did go for the time.
Yes, Your Honor. At this time, the plaintiff would like to call Dr. Emerson Couples. Also, at this time, Your Honor, the plaintiff would like to construct a demonstrative.
Objection.
We haven't started
Oh, yeah, shoot.
their.
Response.
We still have to see
There
it.
was no pre-trial exchanging of demonstratives.
We do that now, stack on people. Lay out in this.
Do any of your experts have demonstratives?
No. You have an opportunity to see one.
Oh my God. That seems true.
It's a little more prejudicial than probably this, but
We'll
we'll
see,
let it slide in.
See what he's.
Your Honor, when you're ready, you may proceed. Good afternoon. Could you please introduce yourself to the court?
My name is Dr. Emerson Collins.
Dr. Collins, why are you here today?
I'm here to determine whether or not Jesse Duran has psychopathic tendencies.
Dr. Collins, what is your educational background?
I have a PhD in psychology from the University of Illinois at Urbana.
And what is your focus to study within the field of psychology?
My focus is studying within the field of psychology is abnormal childhood psychology, childhood psychopathy or both.
And have you published any works related to this case?
I have. I published 3 books, 25 peer-reviewed journals.
And what materials for this case did you review?
I reviewed the affidavits of Danny Brooks, Terry Chapin, Shannon Ellis, Hayden Duran, and Annie Park, as long as several exhibits in today's case.
And in preparing for today's case, who did you contact?
I've contacted 3 of Jesse's former babysitters, 6 of his former teachers, and 11 of Jesse Duran's peer students.
And how many hours total did you spend preparing for today's case?
I've clocked and billed approximately 112 hours.
And did you use any methods when coming to your conclusions for today's case?
I did. I used the psychopathy assessment instrument juvenile, or the PAIJ. It is the standard method that psychologists use for diagnosing a child with psychopathic tendencies. It has been subject to an intensive peer-reviewed study and has an error rate of approximately 0.42%.
And what is your conclusion regarding any potential mental illness that Jesse Duran might possess?
I believe with a reasonable degree of scientific certainty that Jesse Duran displays psychopathic tendencies.
And could you please explain to the jury what exactly is psychopathy?
So what psychopathy is intense egocentrism followed by a total lack of empathy. A psychopath may be able to perform extreme and atrocious and cruel actions without any regards of remorse or regret. They conduct their actions through manipulation, through deception, and lying. And the most dangerous part of them is the fact that they are totally rational in their actions and are not psychotic.
And how did you determine specifically that Jesse Duran is psychopathic?
Well, using the PAIJ assessments, there is a point rating system, and with a baseline score of 12, indicating a consistency with psychopathic tendencies in a minor.
And when you analyzed Jesse Duran, what did you report his score to be on this test?
His score was a 12, which is the baseline score for psychopathic tendencies in minors.
Now, Jesse Duran was 11 years old during the incident. Is this method typically used for children that are 11?
Well, it's typical that this method is used in children ages 12 to 16. It is worth noting that if a person under the age of 12 scores a 12, it would make them even more likely to be psychopathic.
In what specific ways did Jesse display his tendencies?
A variety of his psychopathic tendencies included cruelty towards animals, persistent aggression, guiltless lying and manipulation, and all the while displaying a total lack of remorse, regret.
How did Jesse Duran display cruelty toward animals?
Based on my research and in discussing with one of his former babysitters, at the age of 5, Jesse Duran flushed and killed a cat by flushing it down the toilet.
Objection, Your Honor, seriously, this is not a court statement being offered for the truth of the matter.
Your Honor, respond. This is actually an objection, an exception to hearsay. As under Rule 703, any statements that are made in the aid of an expert witness to come to their conclusions can be reasonably used when coming, and can be reasonably used as an exception to hearsay because everyone's needed these exact statements.
My response would just be that someone telling Dr. Couples that Jesse had drowned a cat in any capacity with hearsay is not a court statement being offered for the truth of the matter.
Do you have a response to the exception that was raised?
No, not that exception.
Would you like to move on, or would you like to continue on that one?
May I restate your question?
Yeah, so how did Jesse Duran display cruelty toward animals?
When Jesse Duran was 5 years old, based on my conversations with former babysitter, He had killed a cat by flushing it down the toilet. And the fact that this incident occurred when Jesse was age 5 years old, it further proves that Jesse is more likely than not a psychopathic individual.
And in what other ways has he displayed his psychopathic tendencies?
For instance, with persistent aggression, for instance, with guiltless lying, Jesse Duran was a notorious liar and would lie about even minor things such as his father's career to his peer students and teachers. Again, with guiltless lying, psychopaths use lying as a form of both manipulation and deception in order to achieve their goals.
Your Honor, permission to approach opposing counsel with proposed exhibit 9.
You don't have to ask permission for opposing counsel, just the witnesses.
Let the record reflect that I'm approaching my witness with the copy. And would you like a first copy? Can you identify what I just handed you?
Yes, this is the notification of student discipline concerning the student Jesse Duran from Fairview Middle School.
And is this a fair and accurate copy?
It is.
And did you use the document when coming to your conclusion today?
I did. It is important as a psychologist to analyze past and previous behaviors of my subject, that being Jesse Duran.
Your Honor, at this time I would like to move proposed exhibit 9 to evidence.
I'm going to check the character evidence if they're offering that Jesse Duran is acting in any way in capacity that they're suggesting in their student discipline document in regard to today's case of intentional shooting.
Your Honor, may I respond? If I could refer you to the case law on page 6, specifically the case of Hamilton versus Walton. In that case, it was reviewed that any testimony about a particular witness that relates to a psychological analysis is actually not character evidence because it is what the witness used in coming to his conclusions today.
Response?
I stand by my objection.
Then overruled.
Can you identify what I'm saying?
Where are we?
You said that Jesse also represented persistent aggression. Can you explain what you mean by that?
So it is very normal for children at age 10 to scuffle and fight around. But what Jesse did, it goes beyond the scope of what a normal child would do in displaying aggression. During a game of dodgeball, Jesse Duran had hit the kid with the dodgeball, and the kid would not go down. Now, well, it would be normal for a person to be annoyed by this action, but combined with intense egocentrism, Jesse Duran punched, kicked, and severely bit the child, and repeatedly stated, "You're dead, you need to fall down and die." Again, displaying persistent aggression on the part of Jesse.
Objection, hearsay again.
May I respond?
Yes.
Related to the objection we just had, this follows under the same law, same rule. This under case law, if you go back to page 6, into the same case, this is a statement that the expert used, referring to his psychological, when he came to his conclusions. Are you referring actually to this? This is actually an exception for a second. Okay. That's where we're getting at. The expert witness used this when coming to his expert conclusions, and therefore it should be admissible.
I agree with that, and I would also note that I believe this document is now evidence, meaning it's not out of court testimony, it's under the document, it's now in evidence.
Yes, sir.
Yeah.
Okay, so would you like me to re-ask the question? Okay, yeah. Your Honor, now permission to approach opposing counsel. Was it a 10 or an even question? For reflection, would you like a courtesy copy?
Yes, I would.
Can you identify my understanding?
This is a drawing titled "Me and My Gun" by Jesse Duran.
And is this a fair and accurate copy?
It is.
Did you use this document at all when coming to your conclusion today?
I did. It is important to analyze the artistic representations of someone someone, and also just as a way of both trying to find the motivations of the person.
Your Honor, I'd like to move exhibit 10 to evidence now. How did you analyze this drawing?
What I found is that not only was it a psychological manifestation of persistent aggression, as noted by panel 5, this is me and my gun scaring all the bad kids away, and displaying and portraying both himself pointing a gun towards two faceless beings. It also shows a rationalization of the violence he's committed. As I said previously, psychopaths are extremely rational beings. He is rationalizing committing persistent acts of aggressive violence by portraying his supposed adversaries as the bad kids.
And permission to refer to a specific document. You also said that Jesse was indifferent to the pain of others. What do you mean by that?
So psychopaths are inherently incapable of feeling empathy, in a sense, the ability to feel the pain of others. When Jesse Duran, for instance, assaulted a child in the gym class, if Duran is psychopathic, he would have faced no internal struggle with it, nor any kind of remorse.
Now, if Jesse Duran were to testify today and claim that he did feel incredible remorse, would you believe his testimony?
I would not. So one of the key components of psychopathy, again, is persistent lying. A psychopath
Objection and proper expert opinion, I would say that Dr. Couples has the ability to assess whether someone's a psychopath or not, and whether or not you're telling the truth is completely out of his professional ability.
Psychopathy is a clinical disorder. This expert is an expert specifically in child psychology and psychopathy, and it's a well-known disorder that has exhibited traits. So, if anything, this expert would have plentiful knowledge of this exact issue.
What I'm objecting to is that if Jesse Duran gave testimony in court today, that Dr. Couples wouldn't be able to know on the spot whether or not he's telling the truth or not. He's not any type of forensic analyst. He's not able to tell if someone's telling the truth or not. He's not trained in that type of academia.
I'm going to overrule the objection because I didn't hear the expert make a statement that definitive. I heard a statement that we believe Jesse, if Jesse were to give that testimony, and also that lying is common among psychopaths, but I didn't even consider that that would be a lie. So I think he's speaking for himself rather than making a definitive statement.
So, would you like to repeat the question? So, do you have any reason to believe that Jesse Duran is not psychopathic?
I do not. In the totality of my evidence and analysis, I believe that I have reached the correct conclusion.
Now, assuming Jesse Duran is psychopathic, does this make it more likely that he intentionally shot Sidney Park?
Of course, many psychopaths display not only persistent aggression, but frequently fantasize committing pain towards others. What makes a psychopathic killer far more dangerous than any killer is because most killers are not psychopathic. But a psychopathic killer will be able to perform their actions without empathy, without any kind of genuine remorse, or honestly any kind of regret.
Now, Your Honor, permission for my witnesses to stand out and interact with the demonstrator. Dr. Thomas, how would you describe the psychopathic tendencies of a child in the ways that we can all understand?
So the way I describe my students about how the psychopathic mind works is that you have to look at like chess. It's a two-dimensional game, plain, and the only goal and has a clearly defined goal. So when we talk about the extreme egocentrism of the psychopath in their own mind is the king.
Object more prejudicial than probative. He's basically breaking down the entire field of psychology into a game of chess, and I feel like it's not as two-dimensional as he's saying it is right now.
How is it going to be prejudicial to the jury?
Just the fact that they're using chess pieces, and what I would assume, I mean, if I make proper, would I assume that they're going to show someone killing a piece off, if I'm correct?
May I respond?
Yes.
In the pre-trial meeting, it was agreed by both parties that this demonstrator would be allowed to be used and would be completely permissible.
What was it? Alright, you know what, fine. Fine. We're sticking by the gentleman's agreement. Couldn't go worse. So,
I'm sequestered.
it couldn't go worse. So let's.
Okay, so continuing your explanation
Another
about
explanation.
how the mind psychopath works.
I don't know what's happening right now.
So with the intensive egocentrism of the psychopath is in a sense the king of the game. And the goal of chess is to eliminate any other king or any other piece in the way. So let's say that poor kid in the dodgeball class. That kid didn't follow the rules. And when a psychopath is wronged or feels that they are wrong, it is as if their whole worldview is gone. So hitting that kid was equivalent to knocking a piece off. Now, if every king needs a queen that can move around freely at any point, this queen would be the victims of psychopathic manipulation, such as a parent, a doting parent who may or may not let things go unpunished, may put things out of the way that questions their little control. Finally, persistent aggression. When a psychopath wants to kill someone, for whatever reason, there is nothing internally holding them back. No regret, no remorse. So the victim in the way of the psychopath, perhaps that being Sydney Park, would have had no chance.
Your Honor, witness, stand up. No further questions. Just ask that my witness.
Oh,
I just ask that I can move the motion unless opposing counsel would like.
No, I'd like to move the motion. I can move that. Yeah, proceed, Your Honor. Dr. Couples, I'm just going to ask you a couple questions today to clarify your testimony. That's all right. This is a civil case, is that correct?
I believe so.
This is not a criminal case?
No.
This means that the district attorney thought that there wasn't sufficient evidence to convict Jesse Duran.
I'm not a criminal attorney, I'm a psychologist.
But you would agree that since this isn't a criminal case, that must have meant that the DA decided that there wasn't enough evidence to pursue criminal charges against Jesse
I
Duran,
do
correct?
not know the DA of Midlands County. I do not know their thought process.
Oh, I appreciate it.
I do not have the expertise to testify to that.
I'm not asking for your expertise, I'm just saying, as a result of there being no criminal trial, that means that there must have been no evidence found by the police or the district attorney.
Objection. Your Honor, this is outside the scope of my witness.
This is cross-examination, we're entitled to more than just the scope of direct examination right now, as well as I'm just asking for his personal knowledge.
I agree
If
with
he's
that,
aware.
but I believe he's told you twice already that he doesn't have.
Well, he specified that he doesn't know.
Are you arguing with me?
I'm responding to your response.
Okay, the objection sustained.
Okay.
Thank you.
So since this isn't a criminal case, and since that there isn't any testimony, or since that there wasn't any criminal charges brought against the Parks, that means that the Parks weren't satisfied with this decision, correct? They weren't satisfied, or they were dissatisfied with the fact that there were no criminal charges?
Your Honor, opposing counsel is calling for my witness to speculate.
Response?
The witness has reviewed the affidavits of pretty much every witness, and I'm asking specifically about the Parks, which he has reviewed the affidavits, and he would be well aware of their state of mind, having to do with Jesse Duran and any pending charges.
Response?
Here's what, if opposing counsel would like to call witnesses to state their own state of minds, I'd be more than welcome. However, my witness is here to testify particularly the state of mind of Jesse Duran.
We do plan to call witnesses to state, as to their states of mind. However, like I said, the witness reviewed all the affidavits, and he's basing his expert report off of these affidavits. Therefore, he should be well aware of their state of mind.
I think this is pretty explicitly calling for speculation, and furthermore, Andy Park testified previously, and you and your co-counsel have the opportunity to ask for specific reasons satisfied with the DA's decision. Therefore, I don't see any relevance in asking an expert for his opinion about Ms. Park's state of mind. Again, this is the definition of calling for speculation.
you testify today?
About $66,000.
They paid you $66,000, and how many hours did you work on this case?
112.
And in that time, 112 hours, you produced a 5-page report?
I did.
5 pages, 112 hours, and only 3 of those pages were a conclusion, is that correct?
I think so, most.
So in the 100+ hours that you spent on producing a 3-page conclusion, did you ever go to the Parks home to investigate the crime scene?
No, the actual forensic crime scene is not my expertise. I'm a psychologist. I am not a CSI person.
But you admit in your deposition that it would have been more beneficial if you had viewed their home, correct?
Would have been more beneficial, but I believe I've satisfied the evidence that I collected.
But it could have not.
Perhaps.
Now, did you ever visit the Duran's home?
No.
And in the same regard, it could have helped you formulate an opinion.
Perhaps, although I had no access to the Duran family.
So after the Parks, they paid to retain you.
Yes.
You interviewed Jesse Duran, correct?
I could not.
So not at one point did you ever speak to Jesse Duran while formulating your report?
Not only would was I not given access, in fact, would have been even less helpful. Psychopaths are extremely deceptive, and in fact, all I would have received is possibly lies if Jesse was psychopathic.
But the basis of your testimony is that you can deal with psychopaths. Would it not be more beneficial for you to meet with someone who you're actually analyzing psychologically?
Unless I was to open his skull and look at his frontal lobe, I wouldn't have gotten much from him.
Well, I appreciate that, but you're not a psychiatrist and you're not a neurosurgeon, you're a psychologist. So what you do is analyze what people say and think,
Yes,
correct?
I do.
And so in that regard, you meeting someone who you might classify as a psychopath, it would be beneficial for you to interview that person to formulate your report. Is that correct?
It was, and once again, I was not given access. I wish I was.
And is it common, though, for the defendant to not be given access to them? In this type of
It is common, although it's not beneficial.
So the method of analysis that you use in your report has a target age range of 12 to 16 in diagnosing psychopathy. Is that correct?
Yes, that is the general age range.
And Jesse was 11 years old when the incident occurred?
He was 11.
So especially given that your method was not intended, so in the field of psychology, isn't there disagreement whether or not labeling a child of 11 years old a psychopath is even appropriate?
There is an intensive psychological debate over whether minors can be classified as a psychopath correct. However, under my understanding of patients, every psychopathic killer is or was once a child. So I do not believe that is a relevant disagreement to this case.
But some psychologists would disagree that you can even label a child of 11 years old a psychopath. Isn't that correct?
Yes, the liberal arts are a very argument. But in my professional opinion, with a reasonable degree of scientific certainty, I am certain that Jesse Duran has psychopathic tendencies.
So the method you used was targeted for 12 to 16-year-olds, and you used this on 11-year-old Jesse Duran. And that was called the PIA.
This is the answer.
That wasn't the answer to the question.
Finish the question?
The method that you used, the 12 to 16-year-old age range, on 11-year-old Jesse Duran was called the PIA-J method. Is that correct?
That is correct.
And so what was the minimum score needed to be considered a psychopath?
The baseline score is 12.
And what did Jesse Duran score?
12.
So despite the fact that you used a method of analysis for children meant to be older than Jesse Duran at the time, and not being able to meet with Jesse, you still came to this conclusion that he scored a 12.
I came to this conclusion because of the fact that Jesse Duran was under the age of 12 when he scored a 12. It is a bigger indicator that he has not only psychopathic tendencies, but more psychopathic tendencies than the average psychopathic child.
But 12 is the baseline, correct?
The score?
The score 12, yes. The
Yes.
baseline for being considered a psychopath, correct? And at any point lower than that, the child is not considered a psychopath. Is that correct?
Perhaps a risk, but we would not consider him psychopathic.
So if you had met with Jesse, and if you had interviewed him, could his score have ever changed?
Unlikely.
Whether it be up or down, could his score have changed?
Unlikely considering the fact I did not interview him.
It's unlikely or impossible?
Not impossible.
Not impossible.
Yes.
Could the score have changed if you met with Hayden Duran? If you got more to know about Jesse and his background, could the score have changed?
Well, perhaps I could diagnose Hayden as a psychopath. that, but I don't think it would pertain to Jesse much.
So it's impossible for Jesse's score to have changed after you interviewed his parent, Hayden Duran.
Not impossible, but improbable.
Not impossible. Could the score have changed if you saw the Duran's home? If you saw the environment that Jesse was born and raised in, would his score possibly have changed?
Well, if he was a violent crime, it would have been even higher, although from what I understand, it was a stable home environment, so I do not believe it would have changed a bunch.
So it could have been higher, like you just said, or it could have been lower. So could it have changed if you saw the Duran's home?
Could have changed, but I don't believe lower.
You don't believe lower, but it could have changed from the score that you've given him?
Theoretically, yes.
And so with these pieces missing, well, you can be fairly certain, you can't be 100% certain that the report that you gave is accurate after not having interviewed Jesse Duran, or Hayden Duran, or seeing the cars or Duran's home.
Or ask me if I can have 100% certainty.
Is there, after saying that the score could have changed due to these factors, is it possible that your report isn't completely accurate?
It is, can I say it is 100% fully airtight? No report is. But I am confident with a reasonable degree of scientific certainty that I came to the right conclusion with the totality of the evidence provided.
Even without interviewing Jesse Duran?
Even so.
Even though the score could have changed?
Even so.
No further questions, Your Honor.
Your Honor, brief recross, redirect. Firstly, would interviewing Jesse aid your analysis in any way?
Not in particular, because as said with the guiltless lying factor of the trial psychopath, Jesse Duran can scream at me, cry at me, tell me how awful it is that his friend died. But if Jesse Duran is genuinely psychopathic, all of this would be nil. It would just, in fact, it made me increase the score. The fact that it would have showed persistent manipulation.
And you reviewed that the house that Jesse Duran came from was relatively modest and didn't seem to be a concern to you?
Well, yes. While it is true that a violent household can make things higher risk, I determined that it was a stable home.
And you said that Jesse's score on this test was 8 to 12, correct?
Yes, the baseline score.
So, if anything,
Time.
You cannot finish your.
okay, last question. If you did go into his house and see anything, would it even be possible for his score to be lower?
Higher, yes. Lower, no.
Any further questions?
No.
You recross.
Or no recrossing, sorry.
May my witness please step down from the stand? At this time, can we take a brief recess?
Sure.
Yeah, the plaintiff rests their case in chief.
How long do we want?
5 minutes?
Yes.
It was over 5, just because we just heard
Because
Maybe, actually.
You can't talk
Okay, I'm
about
trying to
it.
get us brownie points right here, Jesus Christ.
Your Honor, the defense is ready to proceed with our case in chief.
Great.
May I proceed?
Yes, give me a second. Yeah, whenever you're ready.
At this time, Your Honor, we would like to call Ms. Katie Duran to the stand. Permission to proceed? Can you please state your name for the court?
My name is Katie Duran.
Where do you, what do you do for a living?
I'm the Director of Information Technology at the Police Office.
Where do you live?
25 Main Street, Jordan, Kansas.
Who is Jesse?
Jesse's my loved one. He turned 15 this fall. I was only blessed with one child, but this is the one he's my favorite. I said anything I would do to save him.
Why did you decide to live at Fairview?
I was looking for a new house around the time Jesse was 18 years old, and I wanted to raise him in a friendly environment where he can make lots of friends, and Fairview was perfect.
Now, are you familiar with the Parkes family?
I am, and he was family friends. He was so helpful, though. He was so helpful helping raise Jessie, as she had obviously before my father. They moved to Fairview in 2004, and he just gave us this fact about it. He was such a good person.
So to the best of your knowledge, what, if any, often would Jesse be at the Parks home?
I'm being honest, more often than I'd like. As a director, my hours are often out of my control, and I couldn't always be there. But he did so he would be at the process, so it's something I understood today.
Now, to the best of your knowledge, how did Danny feel about Jesse?
Danny didn't always.
Objection, Your Honor, speculation.
Your Honor, if I may be heard, I specifically asked the witness to the best of her knowledge, how did Danny feel towards Jesse? Now, if I may proffer, the only thing this witness is going to testify are experiences that she has had firsthand with Danny. She's not speculating as to Danny's inner thoughts or anything. She's simply testifying as to the best of her knowledge, the babysitter's feelings toward Jesse.
Your Honor, if I may be heard, asking the witness to the best of their knowledge still involves them asking them to speculate about the state of mind of Danny Brooks. If the witness is going to intend to describe interactions that she's had with Danny Brooks, then the opposing counsel can ask that specific question.
Based on the way the question was phrased, I'm gonna give a little bit of leeway, but please do make your objection during the witness's answer if you feel that it's very speculation, depending on the testimony that she gives.
Thank you, Your Honor.
So again, to the best of your knowledge, how did Danny feel about Jesse?
Well, Danny didn't always have the best attitude towards Jesse and his prosecution, for instance. But in retrospect, I should have compensated him for looking after Jesse at the time. He didn't see it as anything other than just hanging out with his friend.
Now, what do you mean by Jesse had a fascination with guns?
Well, Jesse was always interested in the military. Ever since he was a young boy, especially when he learned that his grandfather died fighting for his country in Korea. He used to patrol around the house with the Duran guns and hoping that he would protect me from harm, just like my dad did. As he grew older, his interest dropped from markets at first his classmates.
Now, specifically, how did you feel about buying Jesse these types of video games?
Well, at first I was a bit concerned about the content of the game, so I made sure to like every single game before buying them. There were some that I felt unnecessarily gruesome. I made sure to avoid those. There are others that focused on the strategy on the battlefield that I felt more appropriate.
Did you ever play these games with Jesse?
Of course, all the time. I need to make sure that Jesse understood that the video games, that the guns in the games are very different from the guns in real life, and about the guns in real life video games. And he did understand. Whenever he was playing games, he tended to gravitate more towards the capture the flag style games rather than the melee, since what he enjoyed the most was the camaraderie. It was for that reason I chose not to buy many guns, since I wasn't trying to make the guns the games more realistic than that.
Now, moving back to Danny, did you ever have any problems with him?
We did have confrontation on August 17th. Danny confronted me when he learned that Parks kept a gun in the house, and that Jesse was aware of it. So I told him that I would speak to Danny.
Now, what if anything did you do after speaking with Danny?
Well, I knew Jesse understood the difference between the guns in real life and guns in games, which I reiterated to him. He responded saying that he understood that, which is why he wanted to speak about it in real life. But I put my foot down.
Now, I'd like to move on to the day of August 2010. How did you start your day?
Jesse woke up early that day. I told him I would leave for work for another hour and a half, so he went down to play his games. At around 9 a.m. to do devices.
Now, did you speak with Danny about that night?
I did. She told me that Danny wasn't able to make it that day. I was immediately concerned, but she reassured me that the neighbor Keith Dunlop would be around in case anything happened. I was still concerned, but I had an important meeting that day I couldn't miss. So I pulled Jesse aside and told him to be on his best behavior and to go nowhere near the Parks system.
Now, what if anything happened after you left the Parks home that morning?
I was in the middle of my meeting when I got a call from the police. I went home as fast as I could, and my street flooded with emergency vehicles. I ran to the first uniformed person I saw, the one who was in the house.
What if anything did you see when you entered the Parks home?
There was a rope sheet covering his small body. I couldn't control myself and I let out a scream before falling after the walls and running to my boy, Jesse. He looked so small, sitting on the sofa, surrounded by officers. His face was frozen in shock. I've never seen him make that expression before.
What happened after this?
I then heard that somebody died from a gunshot. Jesse fired.
Did you speak to Jesse?
He seemed to find me registered when I was there. He looked up at me and said that it was Cindy's idea to put the
Objection, Your Honor, hearsay. The out-of-court statement being offered for the truth of the matter asserted.
Your Honor, if I may be heard, and if I may proffer as to the rest of this statement, the witness is going to testify that Jesse said, that he didn't open up the safe with the gun and then Cindy wanted to play, and then after saying this, he broke down and was apologizing profusely. Because of this goes to the then existing mental and emotional state of Jesse Duran, so it is an exception to hearsay.
Your Honor, may be heard. While Jesse Duran's remorse or apologizing might be the then existing state of mind of Jesse Duran, whether or not any statements that he made about whose idea it was to get the gun or any process that Jesse and Cindy did to get the gun would not be state of mind. That would be being offered for the truth of the matter asserted.
Your Honor, it is being offered for the truth of the matter except as an exception, and the reason it goes towards state of mind is because these are the statements that Jesse Duran made, which then showed his then existing mental state, which was that of feeling great emotional, a great emotional response, which does fall under prong 3 of exception 803.
Response?
Your Honor, while any emotional statements that Jesse Duran might have made would be shown as a statement of the declarant's then existing state of mind, any statements that Jesse Duran made about how they acquired a gun, whose idea it was to get the gun, would not be a statement about then existing state of mind. It would be a statement about previous events, which would not fall under prong 3 of this exception.
I agree with that argument. I think it reflects the actions they took and not necessarily state of mind. I think it implies state of mind, but not the exception. Is there a different exception you can propose there?
Well, then, for that case, I would say those statements aren't necessarily being offered for the truth of the matter. They're going to show those specific statements are going to the subsequent action of Jesse Duran, which is then emotionally breaking down and apologizing for what happened.
Your Honor, may I be heard? Given that this is an intentional shooting case, whose idea it was to get the gun and how they got the gun would be considered relevant facts, and any statements made by Jesse Duran about who tried to acquire the gun, I think would be inherently offered for the truth of the matter asserted. If they weren't, then it wouldn't be relevant.
I stand by my objection.
I'm going to sustain the objection. I think there is a way to get this testimony in, so I encourage you to try, because I think it's important to your case, but this time I'm going to sustain the objection.
Thank you, Your Honor.
Now, after you spoke with Jesse, how did he react?
At first his face was very shocked, but after he told me what happened that day, he just broke down and started crying.
Now, what if anything happened the next day?
Next day, it's like one ended nightmare. We went to the DA office. She told me that she was unlikely to press charges.
Objection, Your Honor, hearsay is what the DA told Mrs. Duran.
This goes towards the subsequent action of Ms. Duran and the actions of why we're here in trial today. So after hearing these statements, the emotional response from Ms. Duran, and how we just ended up where we are today.
Your Honor, may I respond? I don't see any subsequent actions that Ms. Duran took based upon the DA's response, so I don't think it falls into that.
Can you proper with the specific action for?
Yes, so specifically, I'm going to, the next question is I'm asking Ms. Duran why she's specifically here to testify, and that is the subsequent action. They were told by the DA that the parties would be pressing charges, and that is why she's testifying today. She's testifying on behalf of her son, and that is my next question, is to elicit that testimony from her.
Your Honor, may I be heard? In that case, we would not object to any statements made by the DA about the parks pressing charges against Ms. Duran and her child, but that would still, we would still object to the DA not pressing charges, because that is not a subsequent action by Ms. Duran.
Your Honor, if I may proffer, the entirety of this witness's statement is yes, she says the DA says they were unlikely to press charges. However, the DA then informs them that the parties are going to be suing and subsequently Jesse subsequent action, they learned that they would be sued and actually secure in court testifying on behalf of her son.
I think it's really the same thing. The parks are essentially pursuing a civil case because there wasn't a criminal case, so I think learning if there would be a criminal case, but the parks are pursuing civil case is essentially one and the same. And ultimately, all of that led to her being here today. I'm going to overrule the objection for now and ask nothing, especially from the other side.
Thank you.
So with that, Mr. Rand, what happened the next day?
So, we went to the office and she told us that she was on my press charges. She did just in prison. I have the charges and all of started against me. And in addition to all of that, she also informed us of the justice I just said.
So because of that, Mr. Rand, why are you here testifying today?
Because I want to sign a good kid. He would never try to hurt me. I am so sorry for what happened. Just see what happened with this the rest of his life. But he was not the same. He would never try to hurt me. And here, he is the caring boy I know I was.
Thank you. No further questions.
Yes, Your Honor, may I proceed? Mr. Duran, you said that your child has a fascination with guns, is that correct?
Yeah, ever since he was a kid, when he learned that his grandfather died in Korea, it really grew respect of weapons and guns like him.
In fact, you're aware that your child Jesse wrote a story called Me and My Gun, is that correct?
I did, I saw the story. I thought it was cute. I used to write stories like that when I was a kid.
Your Honor, permission to approach opposing counsel's witness with what has already been submitted to evidence as Exhibit 10 and drawing Me and My Gun.
Yes.
Thank you. Now, Mr. Duran, did you ever discuss with Jesse what he meant by the statement, "This is me and my gun, scaring all the bad kids away"?
No, I didn't really need to. I thought it was just, kids, you know, like, he didn't see anything, you know.
So, did Jesse ever call Sydney a bad kid? However, Jesse did admit to shooting Sydney, though. Is that correct?
Yes.
Your Honor, may the record reflect that I'm approaching opposing counsel with what has been marked as Exhibit 1. And would Your Honor like a courtesy copy?
Yes.
Permission to approach opposing counsel's witness.
This was already in the hearing, for that.
Permission to approach opposing counsel's witness. Now, you recognize this document, correct?
Yes.
Now, is the statement in Exhibit 1, "No one ever told me how dangerous real guns could be"? Is that true?
I thought that I did my job as a parent. I thought that I educated Jesse properly. I guess the message didn't get there too
All right, would you say that statement is true or not true?
From my point of view, I would say that it's not exactly true.
And the night before August 18th, you actually told Jesse Duran that real guns are dangerous. Is that correct? You also told him that real guns can hurt people, even kill them.
Yes.
And the night before August 18th, you told Jesse that real guns are not like the ones in video games. Is that true?
I did say that.
And Jesse responded by saying, "I know the ones in video games are fake, that's why I want to see a real one."
I did say that.
No further questions, Your Honor. Permission to issue the document from opposing counsel's witness.
So redirect? Yes, Your Honor. Let the record reflect I'm approaching the bench to retrieve Exhibit 1. Let the record reflect I'm exposing the witness. Now, Mr. Rand, were you present when Jesse wrote this statement?
No, I wasn't.
So Jesse wrote this statement without any kind of legal or any kind of guardian present, is that correct?
Yes, that's correct.
So So Jesse wrote the statement when he was alone, surrounded only by police officers.
Yes, I was shocked that they would do that. I made sure, that no questions would be asked. It's just exactly that.
Thank you. No further questions, Your Honor.
There.
No recross, Your Honor.
Can we call him for this? This time the defense would like to call Ashton Rosa to the stand. Thank you for testifying today, Dr. Rosa. Would you be able to state your full name for the record?
My name is Dr. Ashton.
And so what is your educational background, Dr. Rosa?
I have a master's in public health from Tufts University, and in addition to that, a doctorate from Duran University in health policy management.
What kinds of things did you focus on during your graduate studies?
Most of my graduate studies include courses in epidemiology, research methods, and statistical analysis.
So what's your current occupation?
I'm currently a professor at Duran University at the Jacob Miller School of Public Health, where I teach courses in violence prevention and research.
And are you a part of any professional organizations pertaining to your field?
I am. I'm a co-director of the Midland Center for Responsible Gun Policy Legislation. I've been doing that for the past 10 years.
Now, have you ever conducted any research on violence prevention or responsible gun policy and legislation?
Yes, I've conducted numerous studies on responsible gun policy legislation, and in addition to that, I author over 30 scientific peer-reviewed journals on the topic.
Have you ever testified in court as an expert witness in a similar trial to this one?
I have. I've been retained 15 times before. 3 of these times gone to trial, and all of those cases have been against gun manufacturers or owners.
And can you tell us why you were retained to testify in trial today?
On August 18th, 2010, Sydney Park suffered a gunshot wound to the head when her and her friend, Jesse Duran, at the Park's home and retrieved the firearm at the Park store in their home. After Sydney's unfortunate death due to that incident, Hayden Park retained me to determine whether the Park safely and responsibly managed the gun in their home.
Do you have any methods or principles that you use to analyze this case?
Yes, I use what we call in the field a comparative analysis method, which means that I obtain observational data from a particular case and compare it to data from journals and studies about how to responsibly store guns, and then compare the two to reach my conclusion.
And is this method peer reviewed at all?
It is. It's peer reviewed and incredibly popular.
And does this method have a known error rate?
The error rate is less than 1%.
So were you able to reliably apply this method to today's case?
I was. I have access to the affidavits of Annie Park, Hayden Duran, Danny Brooks, as well as Exhibits 3, 4, 7, 11, and 18. And from that information, I was able to observe observational data from how the Parksmen stored the firearm in their home and compare that to journals and studies about how responsible gun safety should be done in home.
So first, would you be able to tell us, if any, what were the risks of having a gun, or what were the risks associated with having a gun in the home?
Well, there's always an inherent risk with keeping a firearm in the home. In fact, even with previous gun owners, firearm accidents increase by 40 to 170% by keeping a gun in the home. And this risk doesn't decrease with experienced gun owners either.
So do these risks increase when there's a child in the home with a firearm?
Absolutely. Now, experts have adjusted the percentages to include situations in home both with and without children, which is why there's such a variation of the percentages. But it's important to note, especially for this case, that the demographic most likely to fall accident to firearm-related incidents are children ages 10 to 14. And both Sydney Park and Jesse Duran were in this demographic at the time of Sydney's death.
And to your knowledge, what kind of gun did the Parks own?
The Parks owned a 6mm 80 Baker revolver.
And was this a responsible gun choice?
To the best of my knowledge, that particular company had not been implicated in any gun-related deaths, so I cannot help the Parks purchase the firearm.
So what can you tell us about where the Parks stored their firearm?
The Parks stored their firearm in their bedroom. They kept it in a safe. It was
a Gucci safe, about 86 pounds, one of the best in the industry, and the only known way to gain access into the safe is to know the combination.
And was this reasonable of them?
I'd say that keeping the firearm stored in the safe was reasonable. However, the choice of keeping the safe in the Parks' bedroom was less than ideal. For one, Sydney had access to this at all times, especially because the Parks had their bedroom door unlocked.
Objection, relevancy. We are here today determining intentional shooting, and where exactly the safe was stored is important if we're determining comparative fault. But in this case, it has really no repercussions on whether or not Jesse intentionally shot Sydney.
I think we're just trying to state that there's not comparative fault, but we're trying to, I guess, suggest the line of how Jesse and Sydney were able to gain access to the gun and why it was so easy for them to gain access to that.
Yeah, so once again, the fact of the matter of where exactly the safe was stored is relevant if we're determining whether or not the parents of Sydney were liable. However, in this instance, we are specifically determining whether or not Jesse did this action on purpose. And the fact that he knew of the gun and the fact that the gun was stored in a particular place doesn't really relate exactly to that.
So I'm going to disagree with you a little. I think Jesse's knowledge where the gun was stored ahead of time is relevant. But I agree with you that it's not relevant to establish specifically whether or not it was reasonable of the Parks to store their gun inside. The Parks' actions aren't relevant. The storage of the gun is relevant as far as it pertains to, again, how Jesse and Sydney were able to gain access to it and the chain of events that led up to the shooting. So I'm going to sustain your objection as far as it goes to reasonableness of how the gun was stored.
Would it have, so where the Parks stored the safe, would this have made it more or less likely for Jesse to gain access to the gun?
To a reasonable degree of certainty, I'd say that it would make it more likely that Jesse would have access to the gun, mainly because while the safe may have had a combination, the fact that it was located in an area easily accessible to the children, and the fact that the bedroom door did not have a lock on it made it very easy for Jesse to potentially gain access to the gun.
And to your knowledge, did the Parks store ammunition in their safe along with the firearm?
I have no personal knowledge of whether the Parks did that on the day in question. What I can say is doing so would have been incredibly dangerous. There's a broad consensus in the firearm industry that keeping bullets.
Objection, relevancy. The witness specified that if hypothetically the bullets were stored in the safe, it would be incredibly dangerous. However, she also just testified that she has no idea about where they were stored.
The witness is just saying that if the ammunition were to be stored, then it would be more likely that
I understand what she's saying. Why so?
it's relevant because that would have directly led Jesse to having any access to ammunition to the gun whatsoever, which directly goes towards
Why is
intentional
it
shooting.
hypothetical relevant?
Why is what was hypothetical?
Ben?
Repeat your objection again.
Yeah, so this witness just testified that she has absolutely no idea where the bullets were stored. So you could ask hypothetical that if they were stored in the safe, would that be dangerous? But because this witness doesn't know, she won't be able to give a relevant answer to the question.
So the answer she's giving now is hypothetical. Why is that relevant?
Okay, well, my question was more or less, did they store ammunition in their safe along with the firearm? I'm just asking the witness that she can say yes or no, however she wishes.
That's
I'm
not the question
eliciting
you
any
asked.
type of speculation or anything relevant.
That's not the question you asked. She's giving a hypothetical answer. If you can't give me a reason why that's relevant, I'm going to sustain your objection.
Okay, I can repeat the question. She, I guess, answer it if you know, that was literally the question I asked. To your knowledge, did the Parks store ammunition in their Gucci safe along with the firearm?
But might I add?
Just say your recollection. What relevant?
That was part of the question, but then the subsequent question was then, would it be dangerous if the Parks had done something that was a hypothetical? So that, in that specific instance, the line of questioning isn't relevant.
That is also my recollection. That's the hypothetical I'm talking about. Your objection is sustained.
So earlier in your testimony, you said that Gucci safes were practically impenetrable. How, to your knowledge, would Sydney and Hayden have gained access to the safe at this point?
The only known way to gain access to the safe is to know the combination.
So then, to your knowledge, did the Parks share the combination with Sydney?
To Through the materials I reviewed, it doesn't seem likely that the park shared the combination with Sydney. However, from my review of the materials, specifically the affidavit of Danny Brooks, it became apparent that Sydney was aware that the file drawer in which the combination is located has all the park's important information.
Was this a responsible decision of the parks to keep the combination in that drawer?
I'd say it was less than ideal. The file drawer was kept in a guest room, which was easily accessible to the children at all times. And in addition to that, the file drawer was unlocked, meaning that they could open it whenever they pleased. In addition, while the combination may not have been explicitly labeled that it was the combination to the safe, it contained a sequence of 3 numbers, which was labeled in a folder. It was labeled for emergencies only, and even to a small child. It doesn't take a leap of logic to figure out that it was a combination to the safe.
No further questions, Your Honor.
Yes, Your Honor. Good afternoon, Dr. DeRosa. My name is Josh Wiskowski, and I'm going to ask you questions to clarify my testimony. So, before we get into the specific facts of the case, I just want to get a little bit of your background. You've been involved in 15 cases, right?
I have.
And all of those cases involve guns?
Yes.
Except, in all of these cases, none of them are related specifically to the loss of a loved one, right?
Previously, in the cases that I have been called to testify in trial for, I've never previously testified against someone who had lost a loved one due to firearm incidents, which is why I was a bit hesitant.
Okay, so also at first, you weren't sure if you wanted to testify today, right?
That's correct, due to the fact that I've never testified against someone who lost a loved one due to firearm violence. But eventually, I came to the conclusion that this would be a good opportunity to portray the violence associated with firearms and the risk that can happen with them.
Right, so you'd say there were 2 main reasons why you decided to come testify today?
To make an example of the dangers of firearms, yes.
One of the reasons, however, was that because Duran offered to double your pay.
That is correct, but I felt that it was more than justified given the amount of work I put into this case and the fact that the unusualness of its nature.
So you spent 21 years researching gun-related injuries and gun violence, right? And you'd say you spent 10 years advocating against, advocating for a new gun policy and for new legislation?
Absolutely, it's becoming increasingly clear that gun violence is a problem and something that is easily preventable, and I'm doing everything in my power through my educational background to advocate for safety, especially in the home and children.
So you call yourself an advocate?
That's it.
And today you're testifying in a case involving gun violence?
That's right.
Okay. So, just to clarify, you are here overall in a case involving a shooting, and you spent over 30 years advocating against guns, and you're testifying against them.
Objection may ask the answer. You've already elicited this testimony from the witness previously or statements.
I'm just trying to make it clear of the bias that this witness inherently has in this case, and while I do understand that I had 2 foundation questions, I just wanted to create a final question to make it clear to the jury.
How is this question different than that question you previously asked?
Well, in the end, it's not inherently different. However, I asked 2 foundation questions, and then I added a subsequent question. This question was just simply putting them together.
I understand that, because you're telling me there's not really a difference on this case.
Understood.
I get the legal advice.
So you base your conclusions on the affidavits of Andy Park, Hayden Duran, and Danny Brooks, right? However, you never interviewed any of them, right?
I didn't think that I felt that, as per an affidavit, the witnesses are required to put all the information that they have knowledge of into the document, so I felt that that was very necessary.
So you thought you didn't need to?
Well, the information they knew were contained in these affidavits, so.
And each of these affidavits was a few pages long, and you think that if you did actually interview with all of these witnesses, that wouldn't have added anything to your report?
Well, more information would always be beneficial, but the primary knowledge that each of these witnesses contain is reported in the affidavit.
Okay. So overall, it would have been beneficial if you had interviewed them.
It would have been beneficial, but it was by no means necessary to know all conclusions.
Okay, so now let's get into whether or not Andy and Lee did what they could to prevent something like this. So Andy and Lee are purchased a gun manufactured by AB Baker, right?
That's correct.
And this company, to your knowledge, is the gold standard amongst gun manufacturers, right?
It had not been restated for the prior litigation, so yes.
And Andy and Lee also used a safe for their gun, right?
They did, though they stored the safe in an
Sorry, could you repeat that too? They said they stored it in an unusual location?
in an unideal.
Unusual location. So when a gun is purchased, it's typically used for self-defense, right?
That's one of the many reasons it used it.
What would the other reasons be for that?
Objection, relevance. The experts here to testify as to why or why not the gun was kept in a safe space, and this has nothing to do with it, or intentional shooting for that matter.
Well, that should be what the experts here to testify to, because that was negligence, which is relevant.
We are here today to discuss an intentional shooting when a gun was not used for self-defense. So if there are any other reasons other than self-defense, this witness could certainly testify a relevant testimony related to that.
If I may. He was saying in general that guns are used for self-defense, not in the specific case whatsoever, and I'm saying that that's not relevant to the expert's testimony.
Well, the gun had to be purchased for a reason. Obviously, the chain of events couldn't occur if it didn't exist in the first place. So I'm simply asking questions that will relate to the storage of the gun, where the gun was located. If I may proffer, I can continue asking questions about why the storage and safe and the location safe was actually reasonable.
Based on that, I think it has potential to be relevant, but feel free to bring your objection and on the answer.
Right, so would you agree that a handgun like this would be used for self-defense?
It's my understanding that that's why the first purchase required for self-defense.
And do you agree that the purpose of having a gun for self-defense would be completely lost if you couldn't use the gun, basically if you couldn't access the gun easily when you needed it?
I would agree that accessing the gun for purposes of self-defense is important. However, the situation drastically changes when there are children involved, and all steps should be taken to make sure children should not gain access to the gun.
Right, but this gun was held in a safe, right?
It was.
With a lock on it?
Yes.
And obviously, if the children didn't know the password to the safe, they wouldn't have been able to get it.
That's correct, but it's become clear that the children did have access to the information.
Right, but this was obviously unfortunate. However, you could reasonably say that the parents of the parks did what they could in order to prevent their children from getting into the safe.
I'd say it was reasonable to purchase them and for them to store the firearm in a safe. But that's, beyond that, their decision to keep the combination to the safe in a file drawer that was located in the guest room where every member of the house can have access to it, especially Sydney and Jesse. The fact that the file drawer did not have a combination on it, all of those contributed to the fact that the parks did not do all that they could to keep us guns.
Okay, so we say that you do agree that it was reasonable to have a safe, and you do agree that it was reasonable to keep it in their bedroom, and obviously to have a safe with a lock. So the one thing that wasn't reasonable was to have a combination without any title or anything. Just
Objection, compound question.
I'll agree with that. You can restate the question.
Sure, I can break something in the questions, but I'll just leave it at simply the one thing that they did do wrong was that, other than everything that they did reasonable, the one thing that they did do wrong was that they put the safe combination without any relevant title in a file.
The way in which they stored the combination was, yes, they stored it in a file drawer that did not have a lock on it, in a room that was easily accessible to children and other members of the household and guests. So really anyone that wanted to find a combination could have done so.
Okay, so moving on, you're not sure if the gun was loaded when it was stored in the safe, right?
That's correct, there's no knowledge.
You know not. And you said you reviewed Andy Park's affidavit, right? And would you agree that in Andy Park's affidavit, she claims that she checked the gun the night before and saw that there were no bullets in the revolver?
That may be true, but what happened the night before, I don't know what happened the night before. It may have been an entirely different circumstance the next morning.
I understand. I'm simply asking that you review this affidavit, and that's what you saw in the
Andy
affidavit,
Park
right?
did state that, yes.
And would you also agree that he claimed the bullets were not stored in the gun? Rather, the bullets were not stored in the safe?
I'm aware that that's what Andy Park claims, however, I have no personal knowledge of whether that was the case.
Okay, and given the type of gun used and your knowledge of this gun, do you believe that Jesse Duran would have known how to fire this gun?
I'm believe that the gun is easily accessible as well as the safe if, I'm sorry, can you repeat the question?
Just simply, do you believe that Jesse Duran would have known how to fire and load the gun?
Because of the fact that Jesse Duran had no previous experience holding a real firearm or loading that firearm, I don't think that would be.
So specifically, it's his lack of experience in holding and loading the firearm previously that means he would be able to do it.
It's not.
Do you think you would have been able to load and fire the firearm?
Well, I've been an expert in gun policy for many years now.
Gun policy, but have you ever actually held a gun?
My personal experience holding or loading guns has no bearing on my expertise in gun storage and safety.
Well, you just said that Jesse Duran wouldn't be able to fire this gun because he never held a gun. But you said you would, however, neither of you have held a gun.
Well, it's also important to know the age difference because I'm an expert with decades of experience in the field. Jesse Duran was a small child who'd never seen a real life person, who'd never held a gun, who'd never loaded bullets into that gun. So
But neither of you. You've never held a gun. You've never.
Objection, Your Honor. I'm going to object to relevance this time and how Dr. DeRosa holding a gun ever previously has anything to do making intentional shooting on Jesse Duran's part more or less likely.
Well, he's making a direct comparison to Jesse Duran's knowledge.
Right, but her specific knowledge is outside of the scope of intentional shooting.
Yeah, so right now we're discussing whether or not Jesse Duran would have been able to load the gun. And I am asking Dr. DeRosa if she would be able to load the gun because the one thing that they do have in common is that they've never actually held a gun. And if anything, Dr. DeRosa has experience related to guns, but specifically gun policy and gun legislation. No, absolutely no experience firing guns, shooting guns, holding guns, touching guns. So in the end, they actually have this one thing in common.
So I guess my objection would be that opposing counsel structured his question to reflect what Dr. DeRosa has studied in her experience with unexperienced gun holders, and that she keep any personal knowledge, which I would deem irrelevant to this testimony, out of the question, as her personally holding a gun, like I said, has no bearing on intentional shooting, and he's asking the witness to compare herself to the witness, which that's not what her research is based on.
Okay. But that doesn't make the question he's asking for relevant.
But he's asking her if she's held a gun before.
Yeah,
And that has no relevance on intentional shoot. Like, that doesn't make Jesse.
that's not correct. No.
Okay.
Josh just explained to you why it's relevant. He's making a comparison
Okay.
based on the testimony the witness gave.
Alright.
So, okay.
So, to follow up, do you think that it might be possible that Jesse might know how to fire a gun and load a gun?
I suppose it's possible based on what I've reviewed of this.
So, you think if he did research, say if he went on the internet and searched how to fire a revolver, do you think potentially he could have gained insight into how to do this? If Jesse Duran went on the internet, because he's interested in guns and wanted to figure out how to load a gun, and he went on a website that taught him how to load a gun, and then he went on the same website that also taught him how to fire a gun, do you think then, after reading this, he could have figured it out? This is simply a hypothetical.
I'm going to object speculation. This is completely outside of her expert testimony. At no point in any affidavits does Jesse describe his state of mind, especially when he's browsing the internet. I don't think she'd be able to testify what he's thinking at the time, or if he's even able to process these videos in his
Opposing counsel is
hypothetical.
not asking about Jesse's state of mind.
Okay.
Are you withdrawing your objection?
I guess, yeah, I mean, yeah, sure.
Are you asking me, do I think it'd be possible for Jesse to do that if he researched what he was learning?
That's exactly it, yes.
Again, I'd say that Jesse's life of experience, the fact that he never held a gun before, the fact that he never loaded or fired a gun, makes him being able to do that less likely.
But my question specifically was that after he went on the internet and after he did research, because he already had an interest in guns, but then he went further to research how to load a gun. And we all know that there are tutorials on the internet for everything. And he went on the internet to find a tutorial specifically how to load a gun. Do you think then, after looking at this tutorial, after looking at the tutorial on how to fire a gun, he would have been significantly more likely to know how to do the job.
I suppose that's possible, but my expertise is in gun storage and safety, not loading them.
So we asked that question. My question is simply, would he have gained further knowledge to significantly increase the chance that he'd know how to load a gun? It's a yes or no question. You believe the answer is no, that even after going into the internet, after finding a tutorial, obviously, to load a gun is something, a fairly trivial action. However, this would absolutely not, in any way, increase the potential chance that he'd know how to load a gun.
Absolutely, so there's no information point saying that anything you came across on the internet would be factual or correct. And in addition, we have no direction of someone actually experienced in the area pointing them out that.
And you would say that this would then make it difficult and maybe even significantly unlikely that situations like this, gun violence involving minors, would ever happen now? You're saying that if it's possible to learn how to load a gun, then kids will never be involved in gun violence?
I'm saying that based on the materials I reviewed, it does not seem likely that Jesse gained added knowledge of how to load a gun.
All right, no further questions.
Attorney Reader?
Just briefly. Dr. DeRosa, is it possible that Jesse might have learned how to, or where to load a firearm from Sydney Park?
That is speculation. This witness we have no idea as to this fact.
I'm just asking for her expert opinion after all the materials that she's reviewed, if it is possible that Jesse could have learned to shoot the gun from Sydney, who owns the gun, is in the home of the gun.
May I respond? This could be an expert opinion because this expert has her expertise in gun policy legislation, not this particular fact.
I'm gonna overrule the provision, if you feel like she's speculating on her answer, please feel free to read the objection, which is based on her questions wording, whether or not it's possible. It really depends on the answer she's giving.
I believe that since Sydney was actually raised in a home that did have a firearm stored within it, that she had more, not necessarily more experience, but more exposure to the firearm, she may have been able to guide us better.
Is it possible that he might have learned this after Sydney might have possibly pulled the trigger first? Is it possible that Sydney pulled the trigger first, showing Hayden, or Jesse, how he needs the gun? And is it possible that Sydney might have loaded the gun without Jesse's knowledge?
That's possible, especially since Sydney had access to the file drawer containing the combination and knew better than Jesse what her parents' storage habits of the gun were.
No further questions, Your Honor.
No refunds.
Your Honor, permission to proceed?
Give me 1 second.
At this time, defense would like to call Jesse Duran to the stand.
It's very realistic 15-year-old.
Good evening. Would you please state your name, spelling the last for the record?
Jesse Duran, D-U-R-A-N.
It's 1:48 in the afternoon.
Oh, sorry. Good afternoon. And how old are you, Jesse?
I'm 15 years old. I was born on May 9th, 1999.
And do you go to school?
Yeah, I go to high school. I'm a freshman.
Then why are you here in court today?
Because on August 18th, 2010, my best friend, Sydney Park, died, and I guess everyone thinks I'm to blame for it.
And And who is Sydney Park?
Sydney Park was the girl next door, literally. She moved in when I was about 5. She was also a safety agent, and we had the same interests. We were instantly became best friends. We were friends ever since.
And what were some of your interests?
We played video games. We watched the same programs.
Now I would like to talk about the day in question, August 18th, 2010. To the best of your knowledge, did you know that there was a gun present at Sydney's house?
Yeah. Sydney talked about it being in a safe in their parents' house somewhere.
And to the best of your knowledge, why did she tell you about the gun?
It was summer. We were bored.
Objection, Your Honor. This witness can't speculate as to Sydney's state of mind or intention behind telling him this information. It's outside of the scope of his knowledge.
I agree with witness can't speculate. I think there's a potential for this to be based on rational perception. For instance, Sydney made it clear why she's telling him that. So I'm going to ask that you wait until the answer gives and then
Yes, Your Honor.
And to the best of your knowledge, why did she tell you about the gun?
In my experience, I think we were just bored. It was summer. It was hot out. There was nothing to do. I think she just brought it up after we were watching Phineas and Ferb reruns.
Objection, Your Honor. I would review my objection at this time that that's not enough information to make a rationally based perception as to why Sydney told him this information. And if he can't answer the question with a rationally based perception, then it's irrelevant.
Are you arguing that it's irrelevant or that it's speculation?
I'm arguing that's speculation, but
I agree with you that it's not enough information for rational based perception, but I also didn't hear a really definitive statement as to why witness believes Sydney told him that.
then, Your Honor, in that line, I'd like to raise an objection as to confusing the jury. I would ask that we have a clear answer to this question. If we just get some gray, wishy-washy answer, then the jury's going to be confused. So if a witness cannot answer this with a clear, definitive answer why Sydney told him this information, then I ask it be stricken from the record.
Alright, confusing the jury is substantially more prejudicial than probative.
It's under Rule 403. Yes.
I hate you so much. I am not going to say that was substantially more prejudicial than probative when the testimony you gave was it's summer, it's hot, and it's windy.
Well, Your Honor, if I may be heard, substantially more prejudicial is just one aspect of Rule 403. Rule 403 also refers to
No, it's not.
substantially cumulative or
No.
substantially confusing the issues of the jury.
No, it's not. Rule 403 is substantially more prejudicial than probative and gives examples of how it could be substantially more prejudicial than probative.
Your Honor, if I may be heard, the rule says excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. It's not just prejudice that testimony can be excluded under Rule 403 pursuant to the rules of evidence.
Confusing the jury is considered to be prejudicial.
It states that the court may exclude relevant evidence if its probative value is substantially outweighed by one or more of the following: unfair prejudice, confusing the issues, misleading the jury. It does not state that it has to be prejudicial. That it simply could be, but it could also be confusing the jury.
Okay, we're getting incredibly confused. Point is, I'm not going to state an objection to this under Rule 403 because it's hot when we're watching TV, it's passing reports. Come on, man.
I understand.
Would you like me to restate the question?
Absolutely.
To the best of your knowledge, why did she tell you about the gun?
I don't really know why she told me, but we were watching cartoons, like we were bored, like that's it. That's all I can say.
And before the date in question, have you ever shot a gun?
Never, no. Unless you count like Nerf guns or video games.
And did you ever learn how to put a bullet into a gun? Now, I would like you to walk me through the events that day. What did you do the morning of June 18th, 2010?
I woke up pretty early. I texted Sydney pretty early. I just got a phone, but I didn't rest it. I went over. I think by that time she knew the foundation for it.
And what time did you go over about?
Sometime before 9:15.
And what happened once Andy Park left?
Sydney was pretty excited. She pulled me to the office where the safe was. Her I'm sorry, she pulled me to the office where the combination was. She pulled out the combination and opened the safe and pulled out a gun.
And what did the gun look like?
I think it was a revolver, just like the ones in the games I played. There was like 6 compartments for bullets.
And was the gun loaded?
No.
Did you ever see a box of bullets?
No.
Did you ever touch a bullet?
No.
Now, permission for my witness to step down and make use of the demonstrative. Thank you.
Your Honor, I would just like an opportunity to see the demonstrative before making sure.
Oh my God.
I'm looking at it. It was never constructed.
Oh, shit. I told circle in this one.
Yes, Your Honor, may my witness make use of the demonstrative with the marker.
I will never forgive you for making this happen. Which shower is talking?
She asked me to.
I'm gonna draw the finger.
Yes.
Your Honor,
Mr. Duran.
I would raise an objection at this time. Jules Sebastian drawing his fingerprint. He's an expert in CSI. He works with fingerprints every day, and Lord knows he's probably seen his own fingerprint several times. A 15-year-old Jesse Duran drawing his fingerprint just by looking at it for just a scale, that is substantially more prejudicial than appropriate here today.
Your Honor, if I may be heard, any witness can look at their own fingertip and trace it onto the board. This is not something that needs expert opinions or expert knowledge to do. And this is not substantially more prejudicial than probative because it's going to be used to show and corroborate with the evidence of fingerprint testing.
Alright. You can draw his own fingerprints.
I'm good.
Hold on. If he is analyzing, interpreting, or comparing that fingerprint, please renew your objection at that time.
Yes, Your Honor.
Certainly look at his finger and draw it up.
Thank you. At this time, I would like Justice Duran to draw his fingerprint onto the board.
If the glove doesn't fit, you must have quit.
Thank you. At this time, I would like your witness to step down. Now, what happened when Sydney took the gun out of the safe?
We were posing with the gun. We were pointing at different objects in the room, pretending to shoot it. To ensure that we could play copies of the gun.
And you know there's, and at one point you left the room, correct?
Oh yeah, after about 5 minutes, I left to I was kind of getting bored. I just left to go watch some TV.
And was Sydney with you when you walked into the living room?
No, actually, Sydney came back into the room about 2-3 minutes later.
And do you know where Sydney was during those 2 minutes?
No.
And what happened when Sydney walked into the living room?
Well, we were watching cartoons, and she suggested that we play like PlayStation. And then I said, oh, we could play that roulette game. And then she said, well, we got
Objection, Your Honor, hearsay as to this own witness's statement towards Sydney. I believe the statement was, we can play the roulette game.
Your Honor, if I may be heard, this is not being used for the truth of the matter asserted, rather it's to show the subsequent action. If I may proffer, this witness will testify that after he mentioned that the 2 witnesses played Russian roulette, it's not used to say we should play the roulette game.
In line with that purpose, I withdraw.
Were you the one to suggest to play roulette?
No.
And what is roulette?
Well, in the game that we, in the video game, I should say, we don't play the actual game where the objective is to go kill a target. We would instead, as a co-op, we would target each other. And by targeting each other, as one person dies, we spawn about 5 or 6 seconds. And then we just kind of went back and forth from there.
So, could you explain what roulette is?
Yeah. So, are you talking about what she wanted to play with the gun?
Yes.
Gotcha. Okay, so at first I didn't really know the rules of roulette, but she explained to me that we would each take turns pointing the gun at each other's head, and shooting, and then she would give the gun to me and I would do the same.
What happened after she suggested this?
I said yes, I didn't really know what she wanted to do here, but I just went with it.
And what did Sydney do after she mentioned the rules?
When we started playing, she took the gun, she pointed it right at my head, and then she pulled the trigger. And then obviously nothing happened.
And what did you do then?
So I took the gun from her, and the gun was kind of heavy, so I had to hold it like this. And we spun the chambers, by the way, I forgot to say that. You spin the chambers, replay it, and then point it. So I did that, and the gun felt a little bit heavy.
And after you spun the chambers and it clicked into place, what happened next?
I just did what she did to me. I pointed the gun like this, held my arm up, fired, and that's when the gun went off, and I fell back on the ground.
And Mr. Duran, can you show again to the jury what it looked like when you held the gun?
So I was holding the gun out like this, but the gun was kind of heavy, even though it was a smaller revolver, and I held it like this just to keep my arm kind of out.
What the record reflects, Jesse Duran is holding his left, his right arm up and his left hand onto the arm. Thank you. And what happened next?
After the shot, my ears were ringing. Honestly, I was in shock. I looked up and there was blood all over the living room. When I say all over, it was everywhere. It was horrifying. I didn't know what to do, so I just called my mother.
And why did you call your mother?
I didn't know what just happened. I was horrified. I didn't know what else to do.
And Mr. Duran, did you intend to kill Sydney when you shot the gun that day?
Of course I didn't intend to kill her. We were playing a game. We both checked the gun, or if there was ammunition in it. And there was nothing. Honestly, people think here that I intentionally did it, but that's not the case at all.
Thank you. No further questions.
Yes, Your Honor. Permission to proceed? Now, Jesse, I'd like to talk about what happened on August 18th. That morning, you texted Sydney before you went over, right?
Is it?
And you recognize these texts if I show them to you in court? Let the record reflect I'm approaching opposing counsel with proposed Exhibit 14, texts between Sydney Park and Jesse Duran. Permission to approach opposing counsel's witness? And would you like a courtesy copy? Now, this is a picture of your text messages with Sydney on August 18th, right?
Yeah.
And this is a fair and accurate copy of these messages?
Absolutely.
Thank you. Your Honor, at this time, I would like to move this exhibit into evidence, constructively redacting the two statements by Sydney Park, only keeping in statements by Jesse Duran into evidence.
Your Honor, I object to more prejudicial than probative. By redacting statements from Sydney Park, it clearly prejudices the jury to the statements of Jesse Duran because they are not giving the full context of the text messages.
Your Honor, that may be heard. That would be true if this conversation were directly based on statements responding to each other. But if you take a look at this exhibit, the two statements by Sydney, wait, no one's even up yet, and then Jesse's response, can't wait to see it. Well, Jesse's response has nothing to do with what Sydney said. So if you remove Sydney's statement from this document, there's no lost context at all. And if there's no lost context, you can't say it's substantially more prejudicial, especially when it has incredible probative value here today.
Your Honor, if I may be heard quickly, the jury is supposed to look at evidentiary facts, and the court here today is supposed to look specifically at case law and law in its entirety. For us to assume the the intent of Sydney Park and her messages and Jesse Duran. That is doing the job for the jury, and it is their job to understand the full context of this evidence. By redacting those statements, we are taking away the jury's ability to look at the evidence and to understand the facts of today's case.
Your Honor, if I may be heard, that would be true if this conversation required that context. If Jesse Duran said something, Sydney responded to that, and then Jesse responded specifically to what Sydney said, but saying can't wait to see it, that's not a response to wait, no one's even up yet. And if you remove that statement from here and just read Jesse's, there's no lost context at all. Especially not to the point where it could be substantially more prejudicial.
I agree with your argument about that particular statement from Sydney. I think the second one does provide additional context. Specifically, it confirms Sydney told Jesse where the combination was looked.
Well, opposing counsel, if they want the jury to see all of this, I would be happy to not redact it and just submit it in its entirety, if that is what opposing counsel really wants, for the jury to look at this whole document.
Your Honor, if I may be heard, admitting Sydney's statement would be hearsay. So for this document, it cannot be admitted into evidence because we need it in its full entirety, and its full entirety is an out-of-court statement being offered for the truth of the matter asserted. Therefore, this evidence has no bearing on today's case in terms of the case law without us as attorneys and as judges making assumptions that the jury has the ability to do.
Your Honor, I'd like to amend my...
Trying to have it both ways. I see what you're doing. All right. You guys come to an agreement. Either he can enter it with those statements redacted, or the statement can be entered with those statements redacted, as long as you agree that you won't object if she tries to enter Sydney's statements across.
That is completely agreeable.
It's up to you two.
Yes, we will accept that.
Which one?
To enter statements into cross.
Okay. Then you're not allowed to object if she doesn't do that.
Yes, of course. Thank you. Now, that morning, you wanted to see the parks done, right? In fact, you texted Sydney over 2 hours before you were actually supposed to be over that day, right?
Yeah.
You said that you can't wait to see it in the text message?
Yeah.
And that's referring to the gun, right?
Yeah.
Thank you. Permission to approach the witness and retrieve the exhibit. Now, that morning, you also spent some time on the internet before you went over to Sydney's, right?
Yes, I did.
And you recognize a copy of your search history if I showed it to you?
Yes, I did.
Let the record reflect I'm approaching opposing counsel with the exhibit of this witness's search history. Permission to approach the witness? Would you like a courtesy copy? Now, this is a screenshot from your phone, right?
Yeah.
And the websites listed here, they're all sites you visited before, right?
Yeah.
And you're the only one who had access to your phone, right?
Yeah.
So you were the one who made all these searches on the internet?
I did.
Thank you. Your Honor, at this time, I would like to submit this into evidence, constructively redacting everything save for the 2 Google searches at 7:15 a.m. and 7:18 a.m., as they were the only parts of this document that are relevant here today.
Your Honor, if I may be heard, this is an out-of-court statement being offered for the truth of the matter asserted, therefore I will object to it.
Your Honor, if I may be heard, you can see here the search at 7:15 is how to load a revolver. There's no truth value being asserted. That is a question. Secondly, the phrase recoil pistol, there's no truth value being asserted from just 2 words into a Google search.
Your Honor, the result would be hearsay. The fact that Jesse Duran had to look up these questions elicits hearsay as to what he gathered information from these different websites and as to why he would look up such questions. There are out-of-court statements being offered for the truth of the matter asserted.
Your Honor, if I may be heard, the only statements being offered in evidence are what's on this document. And the only thing that I'm submitting is the 2 Google searches. How to load a revolver and recoil pistol. What he saw on these sites, that's not in this document being submitted into evidence.
Your Honor, if I may be heard, I will allow opposing counsel to enter those two statements that he looked up into evidence, but I ask that this attorney does not ask my witness what he elicited from those statements, what he read about, what he learned from it, because that would be out-of-court statements being offered with the truth of the matter asserted.
Okay.
Yes, that was my intention from the very beginning.
Okay, then documents received in evidence.
Thank you. Now, you searched these just hours before the shooting occurred, is that right?
Yeah.
And according to your search history, you searched recoil pistol?
Yes, but about probably the day before, we were talking about the gun. She was using terminology that I hadn't really been familiar with, but I kind of just went along with it. I kind of had a crush on her. I kind of wanted to impress her, you know, that kind of stuff.
Just to take you back to my question, you did search recoil pistol, right? And Jesse Duran, you also searched how to load a revolver, right?
Yeah.
And Jesse, just to be clear, you understand the mechanism of a revolver, right?
More or less.
You understand how it's loaded?
Objection. Your Honor, I object because this is hearsay. These are out-of-court statements being offered for the truth of the matter asserted. We had just heard that councilman would not be asking questions that he had elicited from these search engines. He is now asking questions that he could have only gathered information from when searching. Therefore, this is going against what he had originally said when offering these two statements into evidence.
Your Honor, I apologize. I didn't make myself clear. I'm not asking this based off of these searches. I'm just asking if he understood how to load a revolver. I'm not claiming he got it from these websites or some other source of information that would be hearsay. I'm just asking his personal knowledge. If I may proffer, the witness's answer will be yes, he understands how to load a revolver.
I'm overruling the objection. I think that's true. The question was relatively limited in scope. I would also note that the question didn't specify at what time Jesse began to understand how to load a gun, whether it's looking at before this incident or since. So I don't think you could say that this is something he only occurred in these circles.
I'll re-ask my question. You understand how a revolver is loaded, right?
More or less. It's fairly simple.
And you understand the difference between a loaded and unloaded revolver?
Yeah.
And specifically, if you had a chance to examine a revolver, hypothetically, you could tell us if it was loaded or not, right?
Yeah.
Thank you. Permission to approach the witness for treating good. Now, I'd like to talk to you now about what happened right before the shooting. Before you played Russian roulette with Sydney, you thought the gun was unloaded, right?
Yeah.
That's because earlier when you retrieved it from the safe, you checked, and it was unloaded.
Yeah.
And specifically, you opened the cylinder to the revolver, and inside the 6 chambers that make up the cylinder, you didn't see a single bullet loaded. And if it was loaded at the time, you would have noticed, right?
Yeah. 100%.
Because any loaded bullets would be clearly visible when you open up the cylinder to a revolver.
Yeah.
All right, thank you. But later on, the gun did end up firing when you pulled the trigger, right?
Yeah.
So between the time you initially checked the gun and the time it was fired, someone must have loaded it, right? Now, the only people in the house at the time were you and Sydney, right?
Yes.
And you're claiming you did not load the revolver.
Yes.
You're claiming that you didn't even touch a single bullet that day, right?
Yeah.
Now, you know you're under oath right now, right?
Yeah.
So you know that you can only tell truths to the members of the jury here today.
Yes.
And you know what it means to lie, right? And you understand that if you lie under oath, you commit what's known as perjury, right? And perjury can lead to criminal charges, right?
Alright, let's stop asking how 15-year-old people are.
That's the final question, Your Honor.
Okay.
And just to be clear, you're saying you did not touch a bullet.
No.
Thank you. Now, when you shot Sydney, the gun must have been loaded, right?
Yeah.
But right before you shot the gun, you opened the cylinder, didn't you?
Yeah, but I was doing what she was doing. She opened it, immediately spun it, put it back in. That's what I was doing.
Well, you opened it, looked at it, and then spun it, didn't you?
I didn't look at it. I opened it, spun it, closed it, because I didn't think there was any reason to.
So you're telling me that you, just to be clear, you opened it and then spun it, looking away like this?
No, this is how. So I held the gun like this. I opened it, spun it immediately, put it back in.
Well, during your explanation, you were looking down at your hand when you opened it, didn't you?
Yes.
So you looked at that gun when you spun it.
Asked and answered.
Your Honor, if I may be heard, there is a clear contradiction here. I'm getting this witness to give a clear answer to the jury.
Your Honor, if I may be heard, this is more prejudicial than probative. I never asked my witness to, for the jury, do exactly what he had done that day. Therefore, his earlier testimony, his actions, may not necessarily be in cooperation for exactly what he did the day in question, because I never asked him to do those exact motions with his eyes as well. If I did, I would have asked it to be reflected onto the record. Therefore, the jury doesn't even know what you're referring to.
Your Honor, it is not substantially more prejudicial than probative. This witness, he just lied to us. He said that he never
Your Honor,
at his
may I be
hearing.
heard?
I would ask that I'm allowed to finish my statement.
Your Honor, if I may be heard, this witness has said he did not examine the cylinder. That is not lying. This attorney is asking to elicit his own testimony onto his cross-examination, which is going to prejudice the jury.
Your Honor, you can check the record. This witness said, "Let me show you how I did it." Opened it while looking at it, spun it, and then looked up.
May I say something?
No.
Okay.
That is as clear a contradiction as anything. And it's absolutely probative for the jury to understand the
I disagree.
ridiculousness of this explanation.
I don't think it's a clear contradiction. I think you can continue to ask questions about it, but I don't think you can tell us. First of all, during the objection battle, we were exactly room, so I'm not sure why you're down to because they're not here. He says specifically that he opened up the chamber, spun it immediately, and then put it back in place, which to me implies that he was saying he didn't have time to notice that there were holes in the chamber. And he spun it so fast that it wasn't clearly visible to anyone.
Am I allowed
Obviously, I
to?
understand what he's saying.
All right.
So you can certainly ask more questions, but I wouldn't go around telling the witness is lying.
So you're saying that you spun it so fast you couldn't see the bullet?
Well, that's what I said.
Well, I'm asking it for clarification. That's all I can understand.
Well, yes, but I held the gun like this. Instead of, I shot it like this. I held it up like this. I opened the compartment, spun it. I couldn't clearly see the bullet in the compartment.
Well, Jesse, earlier you weren't holding it up like this. You gave us your explanation. Were you?
No, yes, it was.
No, you were holding it down to your lap, right?
No.
I believe you were. Yes, you're right.
I wasn't.
Your Honor, at this time, I would like to look at the record to see exactly what my witness did. If we cannot elicit it from the record, therefore, we cannot question this attorney cannot question my witness as to
Your Honor.
the effectiveness of his earlier statements. There's no clear contradiction.
Tired.
Thank you.
Yeah. It's 2:16. We're getting deep in the weeds. So I'm gonna say conclude this line of questioning quickly.
Earlier when you checked the revolver, you looked at it, right? When you retrieved it from the safe, you looked at it. So the second time you opened the cylinder, you're saying you held it like this?
Yeah, because what Cindy did is what she did. She opened the compartment like this, spun it, as a console effect, and then tossed it back and forth.
Now, you understand that when a bullet is in the chamber of a revolver, it's not held down.
Yeah.
So if you were to position the cylinder like this and there was a bullet in it, wouldn't it fall out?
It would fall out if I was holding it directly vertical, but I was holding it like this.
Well, even if it was angled, it could have fallen out, couldn't it?
It could have, but it didn't.
Jesse, you're saying that you did not know that gun was loaded.
100%.
Thank you. No further questions.
Your Honor, brief redirect. Mr. Duran, just to be clear, you never loaded a gun. Did you ever load a gun?
No.
Did you ever touch bullets?
No.
And when you walked into the living room, did Sydney walk into the living room with you?
No. It was about 3 minutes afterwards.
And do you know where Sydney was during this time?
No.
Do you know what Sydney was doing?
No, I was watching cartoons.
Thank you. And then later, when you were playing roulette with Sydney, can you show to the jury exactly what Sydney did to prepare the gun?
Yeah, so this is what she did. She held it like this, not in vertical, like this. She opened the compartment, spun it, and put it back in place.
And where were her eyes when she did that?
Looking down at the gun.
Thank you. And Could you hold your hands up again during that and let the record reflect this is the hand position of Sydney Park during the preparation of roulette? Now, Mr. Duran, I would like to ask you for you to go through the steps of preparing the gun for roulette. What did you do?
So I just kind of did what she did. I wanted to impress her, so I held the gun, put the compartment thing, immediately spun it. Let it spin for a second, put it back in place.
And where were your eyes when you did that?
At the barrel of the gun, maybe?
And at the barrel of the gun, would you have been able to see a bullet if there was a bullet in there?
No.
Thank you. And can you show again to the jury the hand position you did when you spun it? Let the record
Objection,
reflect.
asked and answered. This is the third time he's now shown this to the jury. There's no new testimony being elicited from this. The record has reflected his hand position at the time.
You agree with that?
Yes, I think we are. Now, just to refer back to the moment that Sydney was out of the room, when you were in the living room, did you have the gun with you?
No.
Who had the gun?
Sydney?
And Sydney was out of the room with the gun doing something you didn't know?
Yes, when she came in, she brought the gun in her hand.
Thank you. And when Sydney, during roulette, shot the gun, did a bullet come out of it?
No.
Did you have any reason to believe that a bullet would come out of it when you shot the gun at Sydney?
No.
And did you intend to shoot Sydney and kill her when you shot the gun?
No. It was under my interpretation that there was no bullet in the gun. To be honest, it kind of scares me that she put a bullet in it.
Thank you. No further questions.
No referrals.
At this time, I would like my witness to step down.
At this time, Your Honor, the defense rests.
You want to take a 2 or 3 minute break before closing?
Your Honor, if the defense is ready, the plaintiff is ready.
I'll remember that.
Yeah, we'll take a minute.
Then we'll accept. Is everyone here?
Yeah.
Your Honor, at this time, the plaintiff would like to move to close the statement.
Okay.
Thank you. May I proceed? Your Honor, opposing counsel, members of the jury, may it please the court, on August 18th, 2010, Andy Barker lost her only daughter, Sydney. Sydney was 11 years old. And Mrs. Park didn't just lose Sydney, Sydney was taken away from her by none other than her own neighbor, Jesse Duran. Jesse took Sydney away from Mrs. Park when he pointed a 9mm revolver at Sydney's head and shot her. Whatever spin the defense would like to put to this story, it was Jesse Duran's conscious and willful decision to shoot Sydney. Today, we, the plaintiff, had to prove by the preponderance of the evidence, meaning more likely than not, that Jesse Duran intentionally shot and killed Sydney Park. Today, we, the plaintiff, did that by proving 3 indisputable facts. That Jesse Duran sought the gun, got the gun, and shot the gun, killing Sydney Park. First, let's address how Jesse saw it. Today you saw text that Jesse Duran sent to Sydney. You saw how Jesse told Sydney to wake up because he couldn't wait to see him. And that Jesse knew where the combo for Mrs. Park's safe was. These interactions fall into perfect accordance with Jesse Duran's obsessions with guns. Today, you saw a story written by Jesse Duran titled Me and My Gun, where Jesse details how he loves his gun, and where he writes that about me and my gun scaring all the bad kids away. The second indisputable fact in today's case is that Jesse Duran got the gun. Now, even the defense has admitted that Jesse Duran got the gun. After all, his fingerprints were found on it. The third fact that the plaintiff established in today's case is that Jesse Duran shot the gun, killing Sydney Park. Today, you heard from lead forensic investigator Jules Sebastian. Mr. Sebastian testified that through the use of GSR testing, he found more than 200 particles of gunshot residue on Jesse Duran's right hand. In fact, he found more gunshot residue on Jesse's right hand than he did on any other surface he tested. This alone was very strong evidence to show that Jesse Duran shot the gun. Not only was this evidence that Jesse shot the gun, the fact that Jesse's right hand had more than twice as much gunshot residue than any other part of his body strongly suggests that Jesse's right arm was extended when he shot Sidney. Mr. Sebastian also found Jesse's fingerprints on the barrel of the gun, the grip of the gun, and a strong partial match on the casing of the bullet that was fired. If forensic evidence were not strong enough, we also have a confession from Jesse Duran himself. I shot Sidney Park. Jesse Duran sought the gun, got the gun, and shot the gun. Your Honor, the defense today would like you to believe that Sidney Park's death was an accident. They would like you to believe that Jesse Duran didn't know the gun was loaded, despite the fact that he opened the cylinder of the revolver and spun it before he shot it. They would like you to believe that Jesse Duran didn't load the revolver, despite looking up how to load a revolver only a few hours before he shot Sidney. They would like you to believe that Sidney touched the bullet and loaded the revolver, despite the fact that it was Jesse Duran's partial fingerprints on the bullet casing. Your Honor, today you heard from Dr. Emerson Collins, an expert in psychology that specializes in psychopathy and abnormal child psychology. Today you heard Dr. Couples explain how one diagnoses psychopathy in someone under 16 years old. Dr. Couples testified as how Jesse Duran displayed persistent aggression by constantly pushing and even biting other children. Jesse Duran showed signs of animal cruelty by trying to drown a cat. Jesse Duran showed signs of guiltless lying when he said that no one told him that real guns are dangerous, despite his own mother saying that's not true. Through the use of the Psychopathy Assessment Instrument Juvenile, Dr. Couples was able to diagnose Jesse Duran as a psychopath. This diagnosis explains how Jesse was able to commit such horrendously violent actions on August 18, 2010. Jesse Duran was able to point a revolver at Sidney's head and shoot her because Jesse truly couldn't feel guilty about it. That's why Jesse put his obsession with guns and his desire to know what one feels like above Sidney's own life. That's why Jesse sought the gun, got the gun, and shot her. Your Honor, we ask that you find the Durans liable for the wrongful death of Sidney Park. And I would like to reserve the rest of my time for the vote.
How much time is that?
3 minutes and 32 seconds.
Permission to proceed? Your Honor, opposing counsel, members of the jury, may it please the court. Intentional shooting. That's what Mr. Houlihan has accused Jesse Duran of today. He told you that Jesse is a scheming murderer who played graphic video games for pleasure. He told you Jesse sneakily stole a gun from the Parks on the date of June 18th. And he told you that Jesse was a child psychopath that held a gun to his dear friend's face and pulled the trigger. Now that's a compelling story, I'll admit. But Mr. Houlihan failed to tell you the fact that Miss Sidney Park was the one who ultimately pulled her father's gun out of the safe. It was Sidney who loaded the gun, and it was Sidney who held the revolver up to her dear friend's face first and shot the gun. Now I want to make it clear, we are in no way saying that it is Sidney Park's fault for her own death. But just because Sidney didn't shoot the fatal blow doesn't mean that Jesse intended to kill her. Sidney saw the gun. Sidney got the gun. And Sidney shot the gun. So when Jesse retrieved it, he had no way in knowing that what he would do would intentionally kill her. And therefore, he had no intent, and he had no proximate cause because it wasn't foreseeable. You see, Sydney and Jesse were just kids. They were little 11-year-olds who hadn't even started 5th grade yet. They weren't killers. They weren't even gun fanatics. They were just curious children who got access to a safe they had no reason getting access to, with a weapon that was far more dangerous than their tiny minds could ever fully understand. And you will see that in Jesse's letter, written in the context of the police, saying that he was sorry that he didn't know guns would do stuff like that, that they could kill people. He thought they were just like the ones in their video games. Because this is intentional shooting, not parental negligence. So it doesn't matter what Hayden told Jesse, because it only matters what Jesse knew, and Jesse didn't know what he did was wrong. Today, the plaintiff had a lot to prove, and they may have proven something. Plaintiff proved that this is an emotionally compelling case. They proved that it is unbearable to lose a child due to unnecessary gun violence. But they could not prove that Jesse Duran shot the gun knowing, to the best of his knowledge, with the intent to kill, and knowing that when he shot the gun, a bullet would come out of it and go and kill his friend. They have to prove to you by a preponderance of the evidence to make you sure more than halfway that Jesse committed an act of willful misconduct. And this means that they have to prove that Jesse acted with the intention and acted knowing he was substantially likely to have killed someone. They also have to prove, again, by a preponderance of the evidence, that Jesse's actions were the direct and foreseeable cause. But they have not done that today. Now let me set you the scene. Let me show you what really happened that day. It was a hot summer day. 2 friends got together. One having access to a safe because her parents left it outside or left it into a drawer that she had easy access to. She was able to retrieve it. She was able to open up the lock, and she took out a gun. Then her dear friend Jesse left the room. He went to go watch cartoons or play games. And Sydney found a bullet and put it into a gun. She then brought it over to her friend saying, "We're just gonna play roulette." And then she took it, spun it, and shot it at him. Nothing happened. So Jesse naively took it as well. Took it, spun it, shot it. He couldn't have known that there was a bullet inside of it because he wasn't listening when she put it there. He couldn't have known a bullet would come out and shoot her because she had just done it and he was fine. How could he have known that he would kill his friend? Now, the plaintiff attempted to understand a child's mind that it was all just assumptions. The only person who could tell you what Jesse was thinking was Jesse himself. And you heard him talk about his inseparable friendship with Sydney Park. He told you even his little crush on her. That is not a reason to kill someone. Now, Sydney's parents show that there was a wonderful friendship between the two. Because how could Jesse ever hurt someone he loved so much? Now, the plaintiff told you that Jesse's apology was unacceptable. But who are we to judge what a child thinks is acceptable to apologize? He said he was sorry, he didn't know. And it's up for the jury to decide if he really meant it, and let me tell you, he did. Jesse was sorry because in his right mind, he didn't know he would kill his friend. He didn't know the destructiveness of firearms. They also never gave a reason as to why he did such a thing. Why would he kill someone? They may have said he had psychopathic tendencies, but they used a scale that is used on 12-year-olds, and he was just turned 11. He wasn't old enough to be compared to that scale. He may have done some questionable things in his past, but he never killed anyone. He never took a gun and shot at anyone. So you can't compare his drawings, his actions towards kids at school, to a murderer. He didn't do that with intent. Now, the plaintiff could also not prove that Jesse's actions were foreseeable. You heard today with Detective Sebastian that there were Sydney's fingerprints on the safe, the gun, the bullet box, corroborating with Jesse's testimony that Sydney left the room and could have put the bullet into the gun. We also heard from Sebastian that he didn't have gloves on. He messed with the evidence, he tampered with it, so we can't really say if Jesse was the only one who touched the bullet. We don't know that. Look at the fingerprints yourself, and you make that assumption. You see, Jesse didn't know there was a bullet in the gun before Sydney went missing. So he didn't know that when he shot it, something would come out, because that didn't happen to him. This is an intentional shooting case. It doesn't matter what Hayden tried telling her son before, it only matters what Sydney or what Jesse thought. And Jesse did not know that he would kill anyone. He had no intention. His sorry is not a sorry of a psychopath who, even Couple said, doesn't have sympathy or have feelings of remorse. No, he is a child that had real feelings of remorse because his best friend is gone. He suffered like anyone else. He lost someone he loved and looked at and cherished. You see, we had nothing to prove today as the defense, but we brought you a case because we know it wasn't Jesse Duran who had intentions of killing you. He didn't do that. Were Jesse and Sydney reckless for playing with the gun? Yes. Was Jesse and Sydney negligent for playing roulette? Yes, they were. But Jesse did not know he could cause bodily harm to Sydney. The plaintiff had to show an intent that Jesse committed an act of willful misconduct. The plaintiff had to show you that this was a foreseeable action. And they did not do that today. They did not because Jesse never imagined that he would kill and harm his best friend. Jesse's a kid, not a killer. Find the Durans not liable for intentional shooting. Thank you.
Your Honor, may I proceed? Your Honor, opposing counsel, members of the jury, may it please the court. Today, the defense said that Sydney Park was the one who sought the gun. Now, that's not true. You saw text messages today that Jesse Duran sent to Sydney Park about how he wanted to see the gun and he knew where the combination was. And Sydney Park specifically said that she wished she did not have told him. The second thing the defense said was that Jesse Duran didn't know that guns were dangerous, that he didn't know that they weren't like the video games. But you heard from Mrs. Duran herself testify today that she repeatedly told Jesse on multiple occasions that guns are dangerous, that guns can kill people, and that they're not like the ones in the video games. Now, there were two people in the house that day when Jesse Duran killed Sydney Park. There was Sydney and there was Jesse. And the defense and plaintiff both agree that it had to have been one of them that loaded the bullet. So let's examine them, shall we? Who's more likely to load the bullet and fire? Sydney or Jesse? Jesse, who had previously drowned a cat, who had a documented obsession with guns to the point that his own mother would admit it, who had fantasized about scaring bad kids away with his gun, and who had a history of violence against other students. Or Sydney Park, someone who didn't even seem to want to touch the gun to begin with. Someone who had no history of violence. Someone who hadn't told a lie in her life that we know. Now, one thing that has been hard to prove today was intent. Why did Jesse Duran shoot Sydney Park? But that's very simple. Jesse Duran had an obsession with guns, and Jesse Duran couldn't feel guilty. You heard from Dr. Couples today testify that psychopaths are egocentric, that they don't feel guilt or remorse. I'd like you to look at the apology yourself and wonder, is this someone who truly feels remorse? Someone who's going to lie about what he knew at the time of the shooting? Someone who said sorry once? Sidney Park's fingerprints weren't found on the casing of the bullet. The only person's fingerprints that were found on the casing bullets was Jesse Duran's himself. Jesse Duran was the one who had the gun, who opened the cylinder, who spun it, whose fingerprint was on the casing. Yet the defense would like you to believe that it was Sidney Park that loaded the gun, gave it to Jesse, and had Jesse fire it in her face. Now, unless Sidney Park had some sort of death wish that neither of us knew about, it seems very unlikely that that would be true. Jesse Duran murdered Sidney Park in cold blood in her own home. And that is why we ask Your Honor today that you find the Durans liable for the death of Sidney Park. Point to rest.
You guys okay?
Are we officially closed?
That's it, bro.
Okay, Carlos, let's just be really happy because I think it was a lot.
What was the line? Just so we can all hear it.
Okay, Nicole came up with this great theme flip. So their theme was Jesse's a kid, not a killer. He was supposed to say Jesse is a kid killer.
Yeah, but they didn't use it in their closing, so I didn't.
Yes, I did.
Yeah, well, I hope you don't take that into account now that I've said that out loud. But.
I hope you do take it.
All right, so let's just do closing
I'm
today,
there.
right? Why not?
All right, let's go.
Let's start over. Yeah, guys. I kind of want to do that, but that's right.
Yeah, let's start over.
It's almost like we're doing it again.
Drawing my fingerprint.
Can we erase the fingerprints?
No, keep those up. I want to use this in the next trial.